Good morning, everybody. It is Wednesday. It is Thanksgiving Eve. Welcome to the Courtroom Files Live. Let's start our day with Judge Vincent Collada, Lake County, Ohio.
And on case number 25-CR-000127, for purposes of sentencing, defendant is present with his counsel today, Ms. Rachel Smith. On case number 25-CR-127, we were last here on July 8th, at which time the defendant entered a written and oral plea of guilty to failure to comply with the order of signaling a police officer, felony of the fourth degree in violation of 2921.331B, and count 2, operating the vehicle under the influence of alcohol, a drug of abuse, or a combination of them, misdemeanor of the first degree in violation of 4511.19A1A. We were originally set for sentencing on August 25th of 2025. The defendant did not appear. As a result of his failure to appear on two separate occasions, case number 25-CR-001313 was filed, and that is 2 counts of failure to appear, felonies of the fourth degree in violation of 2937.99.
All right, we're going to deal with case 25-CR-1313 first. It's matter scheduled for an arraignment. Mr. Atwater, did you receive a copy of this indictment charging you with the 2 counts of failing to appear?
Yes, Your Honor.
Have a chance to look that over?
Yes, Your Honor.
You have the right to have me read that indictment to you, and I'll do that if you'd like me to, or you can waive the reading. What would you prefer to do at this time?
Waive the reading, Your Honor.
Very well, then, as to those 2 counts, how do you plea at this time?
Not guilty.
All right, the court will enter a plea of not guilty. And I'm going to set bond at $10,000 cash surety. All right, now in regards to case 25-CR-127, Ms. Smith, is there any reason not to go forward with sentencing?
None that I'm aware of, Your Honor.
Is there anything you'd like to say on behalf of your client?
I would, Your Honor. Mr. Atwater is before this court on a failure to comply case. Mr. Atwater is a veteran. He served in the Marine Corps. He was twice deployed, suffered a traumatic brain injury that was documented from an explosion. Prior to finding himself before this court, he was established with services with the VA, attending once a month and working on obtaining a therapist. Your Honor, Mr. Atwater's PTSD kicks in as fight or flight, and for him it registers with flight every single time. It's how he came before this court on the underlying offense. It's how he came to flee his sentencing hearing. But he was re-entering the country from Canada after fleeing to see his family for the holidays and then turn himself in. Obviously, he was unable to complete the first part, but he is before the court humble and apologetic. Mr. Atwater understands that under the laws of this state, the court has no option but to send him to impose a prison sentence in this case, despite the fact that at the change of plea, it was offered that there was a joint recommendation for community control in this case. Mr. Atwater also pled guilty to an OVI. His drinking is as much tied to his service and his resulting disability. And despite being incredibly intelligent, incredibly respectful in most of his dealings with individuals, although not in complying with this court's orders, Mr. Atwater understands the court will be imposing a prison term today. He would like the court to consider the role that his PTSD does play in each of both the offenses to which he's pled guilty and the
Well,
ones.
you're asking me just to assume that. I have nothing about that. I gave you an opportunity to provide me information on that, but you chose not to do that.
And Mr. Atwater understands that the only reason that the court is very likely imposing a prison sentence here is because he has made it. So the court has no other options.
But my point is, you're offering these explanations, and I guess I'd like to take your word for it, but I don't have any.
Am I allowed to speak, Your Honor?
You'll get a chance in a moment.
And Your Honor, that is the purpose of a pre-sentence report, and that's why it was critical that it take place here. It did not, and it did not because Mr. Atwater did not appear. And so, Your Honor, we are asking for leniency in the prison sentence that is imposed. Mr. Atwater does not have a criminal history. He does have a record of service with this country as a veteran, I believe that he intends to indicate his remorse and regret to the court in his own words as well.
Thank you, Ms. Smith. Mr. Atwater, you have the right to address the court before you're sentenced. You can say anything you want. Is there anything you'd like to say at this time?
Your Honor, I'm deeply apologetic for the decisions I've made, and this is the most trouble I've ever been in my life, and I've never, a lot of these terms are very new to me. Please, please, just the whole situation is I was completely oblivious to. So
Show up to probation by 9. That's confusing?
Not confusing, just wasn't feasible, Your Honor, because there was.
And you shouldn't have stayed in jail. I gave you a bond because you told me you'd be able to do it.
Your Honor, this is the most time I've ever been in jail. It's a terrifying, scary situation. I have kids. I've never been away from them besides the time of me being at war. And I felt like the time I had spent in jail was worse than war. Like, it completely was. I don't have anything as far as like to say. When I said I could show up, I was planning on finding a way. My mother was out of town. She was in another country, and I was just under the influence. I wanted to get out of jail at that time, and I tried to find a way, and it didn't work out in my best interest, Your Honor. I'm apologetic about that as well, and I just want to say I don't go out with any ill intent of doing any harm to nobody. I've never stole from anybody. I don't be in the world doing anything wrong. The history I have is just driving. The one thing I did on that instance in January, all I was doing is trying to avoid a confrontation at home. I went to the bar, I drove home, and and this situation ensued. There was no craziness as far as I'm not out here doing anything wrong. I'm just trying to raise my kids. I take my kids to football games, cheerleading practice, the normal dad stuff, and just try to live in the world as peacefully as I can. I've been in 3 different trade schools. I do home renovations. I do a lot of different things to not be in trouble or getting in this type of situations. That night was me trying to avoid a situation, and it happened to be this is what happened from it. So I apologize for just the whole situation in totality.
All right, thank you, sir.
Thank you, Your Honor.
Ms. Smith, anything else?
Not at this time as to this matter, Your Honor.
Give me 1 second. Well, Ms. Linden, on behalf of the state.
Thank you, Your Honor. Your Honor, I know we did originally say that we were going to have a joint recommendation for community control, but the problem is if you're going to be on community control, you have to show up. And it's clear that that is a difficult thing for the defendant to do for whatever reason. So the state is recommending a prison term on this matter. He does have 8 days of credit for time served. There is a requisite driver's license suspension on the failure to comply of 3 to life, and then on the OVI of 1 to 3 years. There's a mandatory 3 consecutive days for the OVI, and then a mandatory fine as well, as we'd ask that you impose those. Thank you.
Thank you.
Your Honor.
Hang on 1 second, please. Ms. Smith?
Your Honor, it's my understanding that Mr. Atwater has 8 days of jail time credit since his arrival.
Yeah, that's exactly what I'm doing right now.
Okay.
Let me see
there
what I
were-
get. Do you have a number?
I do not, but there were, based on my records, it appears at least 3 other times.
Well, he's
that
been
he
in
was
jail several times.
Yes.
Your Honor, it was, the original jail time was from November 22nd to November 24th.
January, you mean?
I'm sorry, January 22nd, January 22nd and January 24th. Then after that, from July 7th to July 8th, and now he was arrested here on the 24th, is in custody and until today's date. That's where I came up with 8 days.
When was he was arrested?
On this case?
Yeah, and now, recent?
Now, 24th.
That was the date of arrest or the date he arrived in the jail?
I have from.
What date were you detained at the
Deputy,
border?
from Deputy Robertson,
Monday.
from the marshal,
Talking
who
about
was
the burning here?
apprehended on the 24th.
Okay.
I was in custody
Here,
then.
but let me look at something first. I mean, I'm looking at the docket. I mean, his bond's been revoked 4 times in this case. So back in February of this year, there was a motion to revoke his bond that was granted. The warrant was issued on February 19th, executed on the 20th. So he was arrested on February 20th. Then there was a hearing on a motion to reinstate. And the judge reinstated it at that time, but that's 5 days there.
Okay, I missed that.
20th, 21st, 22nd, 23rd, 24th. So that's 5 days in February, 3 days initially. Then the next month, a motion to revoke bond was granted. He was arrested on March 31st. Motion to reinstate was filed. And that was granted on April 8th. So the 31st through April 8th, he was in jail. That's 9 days. Now my computer's not working. And he was arrested on the 7th because he showed up late for the change of plea. We got him in the next day for the plea, correct, on the 8th?
Yes,
That's when he was released. So that's the 2 days you have there. And then you're saying he was arrested on 11/24
Yes,
till
Your Honor.
today. 3 more days.
22 then?
I don't know yet. 14, 16. I got 20. Am I adding wrong?
3 original, then 5, plus 9, and then another 5.
22.
Oh, yeah. 22. All right, this court has considered the facts and circumstances of the offenses involved here, the nature of the offenses involved here. Consider the history of this case. I don't have a pre-sentence report to review as an psychological evaluation that were ordered by this court as the defendant failed to appear to the probation department to assist in the preparation of those reports, which would benefit him, benefit the court. I've considered everything that's been said here today by Mr. Atwater, his lawyer, prosecutor. All this is considered only the purposes and principles of felonies. I'm sorry. Felony sentencing set forth in 29-29-11. For the factors in 29-29-12, nothing stands out factually in regards to the stated factors. However, the court will note that for the fleeing and eluding charge, the defendant was operating the vehicle under the influence of alcohol or drug abuse at that time, which makes the fleeing charge more serious. Nothing makes it less serious. As for recidivism factors, the court notes, while the defendant may not have a criminal history, he has a horrible traffic history with multiple driving under suspensions, which this coincides with the conduct here throughout, just not following rules and not following orders and court orders, and he just does what he wants to do. Appears to be an alcohol problem, at least related to this offense, and hasn't done anything to address it. I don't find genuine remorse. I don't know how I could find genuine remorse just coming here today and saying I'm sorry, but the conduct and your behavior leading up to this shows no remorse. And other factors indicating relevant factors, just the fact that the defendant's bond has literally been revoked 4 times in this case. First, sit down, please.
Okay. Yes, sir.
First 2 times it's because he wasn't able to pay for whether it was Scram or GPS, I don't remember which one it was, and it was revoked and reinstated. And it got revoked and reinstated. Then in this case, he shows up late for his plea, so it was revoked and reinstated. I've never seen that happen before. Someone's had their bond revoked 3 times and then been reinstated every time. And that's part of the problem here. You think you can just do what you want to do and you're going to get what you want, and then I'll end run. And then it was violated, revoked again because the defendant, when I reinstated it, when he got reinstated for the 3rd time, he was told to show up the next morning by 9 a.m. He didn't show up. Didn't call. Didn't come the next day. Didn't reach out at all. Said you didn't have a ride, but nobody knew that. You didn't call anyone to tell him that.
I was under the influence. I was going to jail, Your Honor. That's all.
It's not an excuse.
Not an excuse. And I feel like there was a lot of miscommunication with the Scram monitor because they said they was going to pay for it, and then I got bound over to Lake County, and then they never told me that I had to pay for it. That's where all that miscommunication came from initially for the Scram
Even
monitor.
the second time?
Yes.
When you got it revoked and again it was reinstated? And you said you would pay for it?
I was paying for it, Your Honor, but they didn't tell me that I had to pay for it. It was surcharge every day. So I was paying for it weekly, but by the time I paid for it the next week, they were saying that I was late. That's what that was about.
I know what it's about.
I didn't know that I had to pay for it ahead of time.
You keep saying you don't know this stuff, and this stuff's explained, but you just don't pay attention or you don't want to hear it. You claim I didn't know I had to be there by 9 o'clock, or maybe it was your girlfriend who called here. Your girlfriend that called here and said he didn't. It was never told what time he had to be there on that day. Well, that's.
I knew I had to be here at 9 o'clock, Your Honor. I just didn't have a ride from Cleveland.
Bond's been revoked 4 times. You've had multiple license suspensions because you just do what you want to do.
All I've done was go to work, Your Honor.
I gave you say what you want to say, because it's my turn to speak, but apparently you have more you want to say. So I'm going to let you say what you want to say, but then it's going to be done. We're not going to go in this debate here.
Yes, Your Honor.
Is there anything more you want to say?
No, Your Honor.
So his bond was reinstated when after he showed up late for the plea. Didn't show up to any of his appointments, didn't call, reach out, didn't do anything. Showed up for his sentencing, and he left. And he's been gone September, October, November, over 3 months. 3 months.
Terrible person, yeah. Terrible person. Worst person.
Attempted to leave the country.
Never left the country.
I said attempted to leave the country. We're not having a debate. I said attempted to leave the country. You were going to leave the country.
Never attempted to leave the country.
Your attorney just said it. And I knew you were arrested of someone trying to get near the Canadian border.
No, I was not, Your Honor. That is false information. I was arrested at home. I don't know where Canada came from.
From your lawyer's mouth.
It was relayed to me by the state, Your Honor.
Your Honor, I can tell you from
Go ahead.
what the marshal said.
I was at home.
So in terms of...
You're going to be removed from this courtroom if you're not going to keep quiet.
Yes, Your Honor.
I've given you every opportunity to speak. I've asked you multiple times if you have anything more to say, and I said we're not going to argue back and forth, and you keep doing it. It's the exact history of what this case is about, that you just do what you want and don't listen to anybody. Ms. Linden?
The information from Josh Robertson from the sheriff's office indicated that they had to ping his phone, that they got the phone number that was pinging within 25-meter radius of Windsor, Canada. It was across the river from Detroit. He had to reach out to Border Patrol to see if he's crossed over, and they were looking at a provisional warrant to give to Canada as a result of that. There was a Canadian counterpart that they were trying to get in touch with as well there. They were going to continue to ping the phone, and then he appeared to be the next day back in Detroit, and they were going to reach out to Detroit at that point in time, and then they continued to ping his phone, and then he was finally apprehended.
Thank you. So again, there's a history here of not complying with court orders and rules. As for factors indicating recidivism is less likely, the court notes the defendant doesn't have any criminal history, led a law-abiding life for significant, he has not a criminal history. I'm going to say he's led a law-abiding life because he's got a horrible traffic history, and that's not following laws or abiding by the laws. Again, the defendant failed to appear for a pre-sentence report, so I don't have a report that was completed, and thus I don't have under the law, the authority to impose community control sanctions. When I look at the history of this case and what this whole thing's about, there's no way the court could find the defendant's amenable to community control sanctions. The very offense itself deals with failing to comply with an order of a police officer. The defendant's bond again was revoked 4 times in this case. The history here is that he doesn't comply. Doesn't follow rules, and he's going to do what he wants to do. So prison's consistent with the purposes and principles of sentencing. Therefore, it'll be the sentence of this court that on count 1, defendant serve a term in prison of 12 months. Count 2, he serve 180 days. By law, that must be concurrent. So 12 months in prison. He has credit for 22 days he's already served. Need to advise you upon your release from prison, you may be placed on post-release control for up to 2 years. If you are and you violate any of those conditions, the parole authority can return you to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half the term I just imposed, which would be 6 months. Any additional prison term imposed for violating post-release controls being imposed as part of the sentence at this time. Court disapproves defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. There's a mandatory license suspension for both counts that's required. I'll suspend the defendant's license for count 1 for 3 years, which is the minimum, 1 year, and count 2, there'll be a concurrent suspension. There's a mandatory fine on count 2 that must be imposed. That will impose the minimum fine of $375. Defendant's also ordered to pay all costs. Is there anything else for the record, Ms. Linden?
No, Your Honor, thank you.
Ms. Smith?
Your Honor, only that in case number 25 CR 1313, Mr. Atwater has executed a waiver of speedy trial in the bond conditions.
Okay, we'll get that filed. Thank you. Anything else?
Not at this time.
Thank you.
All right.
It's the Courtroom Files Live. It is Wednesday. Welcome, everybody. That was an interesting way to start our day here at TCF. He was cranky. Michael pointed out in the chat that he was channeling his inner Glazer. I have no doubt on that. But let's change up the pace and the tenor a little bit, and let's check in with Judge Mercer.
You're here for first appearance accused of 1 count of driving while license suspended or revoked knowingly. Mr. Jones, you have a couple of young ladies in the courtroom on your behalf. Mr. Jones, based upon the text messages exchanged between Mr. Mitchell and Mr. McDaniel this morning, I think Mr. Mitchell may have an announcement in your case. Is that correct, Mr. Mitchell?
Yes, Your Honor. I was able to look at the information that Mr. McDaniel sent the both of us, and I looked up his driver's license info on the FLHSMV website, and it does show that his license is valid. So it's not in our system yet. I won't be able to file an official no information, but I will announce a dismissal on the record.
Thank you, Mr. Mitchell. So, Mr. Jones, what Mr. Mitchell's done ever since he's been in Jackson County handling this caseload, probably 1.5 years, is if someone has no prior driving suspended licenses and they charge with one, and they get their license before the court date, get everything straightened out, he commonly will dismiss the criminal case. I think yours may be the first one that's gotten it straightened out before first appearance.
Yes, sir.
But it's fairly common for people on the first offense to figure out what the issue is, insurance, fine, whatever, unpaid ticket, and resolve it before the court date. So since your case has been resolved, you've gotten your license straightened out, and since it was your first offense, Mr. Mitchell's announcing a dismissal of this charge. Is that correct, Mr. Mitchell?
Yes, Your Honor. I just don't know if he
Did I
was
misexplain anything?
I was just saying, I don't know if he has been given any civil citations in addition to it. If so, those need to be addressed.
No, sir. I got a warning. That's it.
Okay. Mr. McDaniel, anything else from your perspective?
No, Your Honor. Thank you.
So in light of the pending dismissal, Mr. Jones, I'm going to give you an ROR. That means you're going to get out of jail this morning. Mr. Mitchell's office will dismiss this case next week. Once it's submitted to them, again, their office is closed today for the state holiday. So Mr. Jones, you'll be released this morning. So ladies, what that means is they're going to process him out. By the time they get him processed out and back in his regular clothes, usually that's about a 30-minute process. He can be picked up at the jail in roughly half hour. Someone going to be able to pick him up? They've got transportation covered. They'll be there to pick you up. Mr. Jones, do you have any questions?
No, sir. Thank you.
Wish you the best, sir. Thank y'all for coming.
Thank you so much, sir.
We have Michael Whitaker next. Mr. Whitaker, come on up, please. Mr. Whitaker, good morning. Mr. Whitaker, you're here because you've been accused of driving while license suspended or revoked also. However, yours is 4th or 5th offense, depending upon how you look at it. In your case, it's a failure to appear warrant. I'm appointing the public defender's officer to represent you in this 2020 case. I'm going to ask that you listen to Mr. McDaniel, your attorney, and we'll see where we stand, sir.
Your Honor, I spoke to Mr. Whitaker, and he just, he wants to address the court before we do anything.
Okay, Mr. Whitaker, go ahead, sir.
I was just trying to see what, in a way possible, that I can be able to get out in it. Like, I mean, I know the case is 5 years old, and I know I failed to appear And I know y'all have to do your job or whatever. You feel me? Well, all I'm saying is like I don't know what to say right now because at this point right here, like 30 or 30 to 60 days or however, whatever your decision is to put action to whatever my crime that I appear to do. I was just trying to see, could you have a heart to just look at the circumstances or to understand like it's the holidays, and I know you have family just as well as I have family. I have kids that ain't gonna see their father for the holidays, and I have a job, and I'm gonna lose my job from this place for $38 an hour, sir.
Mr. Whitaker, let me ask you a question. Let me ask a question. I know that you were arrested for felony driving with suspended license based on your fourth or fifth. And that's how we finally got you back, because you got arrested in a neighboring county. And they held you over there for several days, it appears. And then we finally got you over here after 5 years. My question for you is, I don't know how you got out over there. Did you post a bond in that county, or were you released in some other manner in that county?
Judge, Madison County is pretty consistent that they don't hold him back for that. They give him ROR immediately upon arrest and call the sheriff's office to come pick him up. So he has 7 days jail credit.
So he didn't go to jail on their charge. He only went to jail on our charge. Is that right, Mr. McDaniel?
Well, they give him a notice to appear, you know what I mean, when they get to the jail, and it was an ROR, and they sent it, so he's got 7 days jail credit on this.
Okay. So this warrant was issued back in 2020, and at that point, we put no bonds on failure to appear. I put no bond on all failure to appears. Since then, Mr. McDaniel, you've made an argument probably 2 years ago that if they were never arrested and they hadn't been posted bond previously, and that they weren't sent a notice, other than, in this case, allegedly sent a notice, but that there's no evidence they received that notice that they were entitled to a bond. Mr. Mitchell, do you agree that in this case, Mr. Whitaker is entitled to a bond, even though the original warrant 5 years ago says no bond?
Yes, Your Honor. I'm okay with.
Okay.
I'm in agreement with him getting a bond.
Mr. Whitaker, I'm going to set your bond at $5,000 cash or surety. You've got a condition not to drive a motor vehicle. As far as anything other than that, that's all I'm not going to do anything. I'm not going to. You still may be looking at the same sentence if you're convicted of this, but you haven't been convicted, and you've got the right to post bond. Your bond is $5,000. Again, you've got a condition, no driving at all. You've got a horrible driving record. It appears that you continue to drive without a license. You've got at least 3 convictions for that in the past, 1 charge within the last 2 weeks in another county. So that's your bond, and you get a chance to use the phone in a few minutes to try to post the bond. I'm going to ask the jail to give you a notice for your court date, which will be
January 5th.
January 5th at 9 a.m. Mr. Whitaker, do you have any questions, sir?
Yes, sir. If there's any way possible, I can that you have the ticket in front of you, the how much it costs or anything, sir.
It's a $400 fine if you get convicted.
Okay.
There's a fine in this case if you're convicted, but in your case, because of your driving record, there also may be a jail sentence, depending upon what happens in court. But you've got the bond set now. Any other questions?
No, sir. That's all. Appreciate it. And thank you for your time.
Have a good day, sir. We have Robert Merritt next. Mr. Merritt, good morning. Mr. Merritt, you're here because you've been accused of 1 count of trespass after warning and 1 count of third or subsequent petty theft. That's a felony charge, sir. Mr. Merritt, there is probable cause in the complaint, and I've also looked at your criminal history. Mr. Merritt, I think you're entitled to a bond, but let me see if the attorneys have any additional information they want to make sure I'm aware of. Mr. McDaniel, anything on behalf of Mr. Merritt?
Your Honor, I don't think he's going to be able to post any bonds. I don't know if it's going to matter, but I mean, you've seen the complaint, and I know Mr. Merritt is, he's don't have any money, and sometimes he probably does stuff, and I know the amount is probably $5 worth of food or something. So just take those things in consideration, but I don't think any bond's going to matter. So.
Let me see what it looks like it's less than $10 in items. Mr. the problem is he's got a petty theft from within the last year or so.
Same kind of thing.
And then he's got three prior petty thefts. That's why it's charged as a felony. Mr. Mitchell, anything on behalf of Mr. Merritt, sir?
Just a reasonable
Or
bond.
anything on behalf of the state? Okay. Mr. Merritt, I can't give you a conditional release with the history you have, but I'm glad to set your bond. Mr. McDaniel, I know that you said he may not be able to post it either way. Do you have a preference on, does he have a preference on cash versus surety?
You don't have any cash.
Mr. Merritt, I'm gonna set you a $2,500 bond on each case. It's cash or surety. Mr. Merritt, you have the right to go through a bondsman, sir, but your criminal history is what's getting you the bond in this case. Mr. Merritt, you'll get a chance to use the phone in just a few minutes, sir, to try to post the bond. And Mr. Merritt, you've got a condition of no contact with any Dollar General. Now, they've already got you a trespass warning at that one. That was issued before yesterday. Okay, that police department says that you were, and I just know what the complaint says. I know they're accusing you of that. So, Mr. Merritt, what I just want to be clear about is right now there's an order. I'm going to order a bond condition of no Dollar Generals at all. So it can be confusing. Can't go to any Dollar General while this case is pending. Once this case is over, then we'll see what happens. But right now, I need to keep you out of Dollar General because it appears they don't want you in those locations. Mr. Merritt, do you have any questions, sir?
No.
Have a good day, sir. Court date, it'd be a felony court date right now, which would be
January 6th, maybe?
I don't have that list back either. Mr. McDaniel, I don't have the new list back. Do you have that? We had to get it changed yesterday because it wasn't illegible. Do you have the court date?
Oh,
it's the same one you have. It's just when we tried to look at it, I couldn't read it because of the color combinations. It was too dark.
January 6th, I believe it is. January 6th. I can look it up.
January 6th at 8:30. If you give him notice for that day, please, Corporal. And that brings us back to Mr. Pittman.
Oh, Mr. Pittman, come on in.
Mr. Pittman, good morning. Mr. Pittman, you're here back for first appearance again. Your cousin, Mr. Hudson's in the courtroom, sir. Mr. Pittman, the law enforcement, I held you yesterday because I didn't feel there was probable cause in that complaint for assault. They have since amended the charge, and they've now accused you of one count of culpable negligence. What that charge is, it's a misdemeanor offense, and they're basically saying, Mr. Pittman, that you're culpably negligent for taking your mother out of the facility she was in and putting her in an unsafe environment, an inability to take care of herself due to her medical or physical condition or mental health condition. That's what you're accused of. It's a misdemeanor offense. I have read this new complaint carefully. I actually went and pulled the culpable negligence statute to make sure I understood what the elements of the charge were. And there is, yesterday you wanted to represent yourself for first appearance purposes. Is that still the case, sir?
That is, Your Honor.
Mr. Pittman, anything you want to be heard on probable cause on the new charge of culpable negligence?
Yes, it is, Your Honor. Can I speak?
Before you say anything, let me give you this caveat. Mr. Pittman, we're being recorded. You're the defendant. Yes. If you talk about the charge itself, this recording could be played and used against you. So I would encourage you, do not talk about the charge itself, but if there's a legal argument you would like to make, I'm glad to listen, but I wouldn't talk about the allegations against you because you're the defendant and you've chosen to represent yourself at least up to this point. So is there anything you would like to tell me about probable cause or any legal argument you would like to make?
Well, I first would like to make a legal argument as far as an objection to these proceedings. Number one, I was never given my Miranda rights at any time. So I object on that ground first.
Mr. Pittman, okay, Miranda only applies to in-custody interrogations. There's no evidence of any statements they're using against you or trying to use them against you. Therefore, Miranda doesn't apply unless they're trying to use statements against you. Had you accepted my suggestion that you get an attorney, you would know that, or your attorney would know that, but that's not a valid basis to object to anything unless they're trying to use statements against you, which they're not so far. Any other points you want to make?
Well, I anticipate that they will. So I've expressed that one objection. Okay. Objection number two. Objection number two is that my name is Randall Pittman. In 2003, I'm sorry, 2007, I became a private attorney general for the state of California.
Your Honor, I'm going to
And-
object to
and-
this. This has no bearing on probable cause for this fact
Your Honor, I
pattern.
have a right to speak. I have a right to speak. And
Mr. Pittman, you
because
have the
I
right to
am-
speak on probable cause, but that's what we're here for, is
no,
whether or
I'm
not there's
making my
probable
objection.
cause.
I have a right to make 3 objections. I'm just making 3 objections, and just let me do that, and then we can proceed. I'm a private attorney general of the state of California. I've been working undercover for them for about 20 years. And I am disclosing that information. So what that means is that this court has no jurisdiction over me because I'm a
Okay.
California
Yeah,
private
you're
attorney general.
wasting our time. You're wasting our time. Even
Okay.
if you were a private
Okay.
attorney general, that has nothing to do with whether or not we have jurisdiction over you if you're accused of a crime. Mr. Mitchell,
Okay,
anything
so-
from the state regarding bond, sir?
Your Honor,
So
we would
I'll
just
move on
ask
to
for a reasonable,
question-
Mr. Pittman. We
Yeah.
would just ask for reasonable bond under this situation and absolutely no contact whatsoever with his mother, Willie Ruth Pittman.
Mr. Pittman, I'm gonna set you the standard bond I would for just about any misdemeanor charge. That's $2,500 cash or surety. Mr. Hudson, I apologize. I didn't give you a chance to speak on Mr. Pittman's case. I know you have some things to add on her case. Anything you want to add on his case? So, Mr. Pittman, your bond is $2,500. The same set on just about every misdemeanor. It's cash or surety, Mr. Pittman. You'll use your phone in just a few minutes, sir. You post the bond, you'll be released. Mr. Pittman, 2 more things. Number 1, I'm going to ask the jail to give you a notice for your arraignment date, which will be January 5th at 8:30. Secondly, Mr. Pittman, you do have that still condition of no contact with your mother for the reasons I put on the record yesterday, and even more so now that you've been accused of a crime directly relating to lack of providing care for her. So you've got a condition of no contact with your mother, at least temporarily. Mr. Pittman, do you have any questions, sir?
Yes, Your Honor.
Okay.
I have paid for a 24/7 caregiver for my mother who was at the house when I was arrested. I did not know she was being arrested. If I had known, I would have made sure that the caregiver would have taken over right then.
Mr.
And
Pittman,
for you to not listen
Mr.
to
Pittman,
me-
you're commenting on the case that you're accused of, and I've told you that's a bad idea. I'm going to stop you because you're going to hurt yourself is what you're going to do. You need to talk to an attorney, a real attorney. You need to talk to a real attorney, Mr. Pittman, that's licensed in
I
Florida,
don't want to be
is my
rescued
suggestion.
by white society. I'm an African
Your first
American.
appearance is completed. I'm not going to try to talk over you any longer. Have a good day, sir.
Thank you.
Okay.
We'll talk to you soon, buddy.
So, Mr. McDaniel, is it Mr. Hudson or Dr. Hudson? Dr. Hudson is here. Mr. McDaniel, it's not on his case. He needs to be taken out of the first appearance room. Dr. Hudson, do you mind coming up, please?
Yeah.
I need them to.
Judge,
hear
just a
what you're-
clarification, because you said that they amended it to this charge. Does that go away with the charge yesterday? The jail and me are both a little bit confused. Or is this a new charge on the new case number? Or?
Come on up, Dr. Hudson. So we'll clarify this first. Mr. Mitchell, what's the state's position on that?
I think from what we had what I've had discussions with the investigator in this matter is they amended the complaint for the yesterday's charge also and added this one in addition.
So it's going to go in the same case number?
No,
Yeah.
The complaint doesn't say amended anywhere.
Oh.
So it's going to be set up as a separate charge. I found probable cause. So we got 2 complaints that's not amended. So he has 2 charges, one of which I found no probable cause. That's the assault with the ROR. The second charge is the one I found probable cause on. I've set the bond on today. So what y'all may dismiss that assault if you choose to, Mr. Mitchell, but because this is not an amended complaint, it's just a regular complaint. It's not amended. It doesn't say amended at all. So if that was their intent, they didn't do amended complaint. They just did a regular complaint. But either way, we can get to where we need to go and get in court. Don't do everything else.
Oh, did you say ROR on that charge from yesterday? That's what the jail's telling me you said.
No, I didn't set it. Oh, you're right. I found no probable cause, but he waived that.
Yes,
And he
sir.
gave him
Thank you for
5,000
correcting
bond.
me. I said 5,000 on that. That was an assault. But the only reason I did that is because he was waiving that right. So, Mr. Mitchell, what's the state's position on that?
We could keep it as it is right now until probable cause is challenged. I mean, he's representing himself right now and he waived that.
I'm not comfortable with that. I wanted to hold him, Mr. McDaniel, because I want to give the state time to get the complaint correct. I don't think that's really fair to him to set a $5,000 bond on that assault, given he waived probable cause because he was trying to get a bond set. He wasn't able to post the bond, obviously. So I'm going to change that $5,000 bond to an ROR on that case. I guess it's possible the state to go forward with an assault. It's hard for me to imagine them being able to do that on a conditional threat like that. And I fully thought they would amend that complaint, but they didn't. They just filed a separate complaint. So to make it clear and try to be extremely fair to him, he's got an ROR on the misdemeanor assault. Probable cause was found only by agreement, not by fact. And he's got the bond I set this morning. So he's got a total bond of $2,500 cash or surety, to clarify. Thank you. So Mr. McDaniel, Mr. Mitchell, this is Dr. Hudson. Dr. Hudson was here this morning. My understanding from Dr. Hudson, talking to him real briefly about just to see what his role was. He is the nephew of Miss Pittman and the cousin of Mr. Pittman. But Mr. Hudson, Dr. Hudson came to be heard. He has some information on Miss Pittman. So Mr. McDaniel, I know that you're trying to get her out and find out where to go. So Dr. Hudson's here to give us an update on what efforts the family's been able to make thus far. Doc.
Okay, good morning. I'm the nephew of Miss Willie Ruth Pittman. My mom is her sister, but I'm also the cousin of Randall. We've been having issues, as this court knows, for a couple of years with him. And I don't want to seem negative, but taking advantage of her situation. As you can see, there's some mental issues with him as well, but she definitely has dementia and also mental health issues. It is hereditary. And so I've been trying to become her power of attorney. He has a power of attorney on her, as well as her health. And that's why he's able to do the things that he's been doing. We've had her in several facilities in Jackson County, and each time he goes and does something, either alienates the staff or just takes her out and takes her home. This time when he took her out, she was in Tallahassee, where I live, in a facility. We were trying to get her stabilized, and I had my lawyer to go meet with her to see if she would allow me to become the power of attorney. She agreed at first with me there, and then she wavered and didn't agree. And then I think he came to court, and because she was in the facility, they dismissed the previous charges against him. And so he was able to go and take her out. I've been trying to get him stabilized, to get him a job and everything. I even gave him a vehicle to get to work, and he turned around and used that to travel and get her out. And so I just had a question. Can his power of attorney be overwritten? And because of her mental state, could someone else, she has 2 other sons, but they're not in a mental capacity to be able to do it as well?
There's 2 ways to essentially in Florida, there's 2 ways to get rid of a power of attorney. One is if the person granting the power of attorney revokes that power of attorney. It's called a revocation. She has to be competent to do that, and she has to do that in writing, just like she would the power of attorney. The second way you can override a power of attorney is called a guardianship. Okay. A guardianship or an emergency guardianship is where you, someone would hire an attorney. The attorney would ask the judge to create an emergency temporary guardianship, and that guardianship would override the power of attorney. Typically, that's going to have to be accompanied by some type of medical documentation, doctor's notes, doctor's recommendations, something to support it. Sometimes it may also have to be accompanied with some reason. Normally, your children are your guardians, so you have to have a reason to say, Judge, in this case, if your position is this, the child or children are not appropriate guardians, and here's the reason. So that's the 2 ways, the 2 only ways I'm aware of in Florida to set aside a power of attorney, those 2 ways. Okay.
So would her other son, his Randall's twin, be able to request a revocation of his power of attorney?
She can. The revocation of a power of attorney is a simple form she signs. It's got to be appropriately notarized and witnessed. Okay. It's got to be prepared. And then what that does is that gives her no power of attorney, and then she needs a power of attorney, arguably. Right. So if she chose to issue another one, she could sign one and then immediately sign the next one, naming whoever the new power of attorney is, whoever that is, if she decides to do that. But she has to be competent to do both of those.
Well, what if she's not competent to
If she's not competent, then guardianship's your only option.
Guardianship. Okay. All right.
So as far as placement goes, it sounds like even if he has no contact, the power of attorney that's currently in effect is an issue or roadblock in placement. Yes. Mr. McDaniel's is trying to get her out, I would consider any type of release options to get her out. I've just got to have a place for her to go.
Right.
Okay. Any additional information that you need, or any questions you have for the attorneys?
No, I'm just, thank you guys for working with her. I know it's difficult, and specifically in her mental state, because even with me, she's kicked me out of the room at least 20 times. And so that's why it's sort of challenging to get her to see what's in the best interest of her.
Yes, sir. Mr. McDaniel, any suggestions or advice in her case of where you want to try to go from here? Are we kind of handcuffed until we get placement options, or what are your thoughts?
My thought is just like that text I sent. It's the sheriff's office duty to contact DCF when there's an elderly person that's in danger. DCF shows up at their office and interviews her and talks to her, and then tries to find placement with them. They've completely skipped that step to basically bring her to the jail. You know,
that's not what the complaint says. The complaint in his case, or the complaint in her case, goes in great detail about what efforts the sheriff's department made, Mr. McDaniel, to try to find alternative placements. And I don't know it's as easy as you're portraying it. They according to that complaint, they went to a lot of effort to try to find a place other than jail, and they didn't have anywhere, is what I'm reading.
I read it as that they were calling the non-emergency number, and they were not. I mean, but if a person is just like a minor child is in danger, they'll take them to their office and they hold them there and they'll call the emergency number, not the non-emergency number report. They said the complaint that they reported it to DCF, but when you're sitting in their office, they'll have someone call them on the phone and talk to them and say, we've got this person here that needs assistance, and and they'll come out there. I did not see that happen. They brought her straight to the jail, and they did non-emergency calls. I agree with that, but they didn't do the emergency call, just like you would with any minor that gets arrested.
I think you're second guessing them, and I just don't know that's fair given the complexity of the situation. But I'm willing to release her to any reasonable location immediately. Just got to have somewhere to let her go. Let me see if Mr. Mitchell, anything from your perspective?
No, Your Honor, we're in agreement that she needs a better placement once some placement has been found. So,
Dr. Hudson, she hasn't been determined to be incompetent. Let me put it that way. I'm not saying she's competent. I'm just saying she hasn't been determined to be incompetent. So if she either agrees to go somewhere voluntarily, live with a family member or a friend that's going to take care of her and it's a safe environment, or if there's another way, such as a guardianship or a valid power of attorney to get her somewhere, I would certainly consider that. I'll get Mr. Mitchell's input, Mr. McDaniel's input. But I can't just say, put her out of jail, send her out the front door. Right. Can't do that.
Yes.
In good conscience.
I understand. And it's probably safer to be there than to be out on the streets anyway. So, because there's not a family member that can control her, and to be there 24 hours a day.
Well, thank you for coming, Doc. And if you get any additional information, please pass it along to Mr. McDaniel, and then he'll pass it along to the rest of us.
And I do know the sheriff's office was trying. They said it may be a place in Ponce de Leon that she may be able to go. So I'm going to call her again today from the sheriff's office to see if.
Who is that contact person that you were talking to there?
Probably Investigator Willis Hodges.
Peggy Hodges.
Yeah, Investigator Hodges.
Yes.
Yeah, I know that she's been working on this case a lot. She called me. They made the first arrest with warrant questions, and I explained you don't have to have a warrant. At that time, it was spitting on an officer, I think is what he was accused of, and she was accused of spitting on an officer. So there was no warrant because it was a officer. The felony allegedly occurred in the officer's presence, but I don't think they were wanting to charge her. They were looking for other options. They just didn't have any.
Well, they didn't know, and they've been experiencing that as we have as well, because she does the same thing to us and throw things and different things like that. That's why we're trying to find a facility that can manage that.
Well, if there's a way to get her to a facility, I set her a low bond, but I would even consider something else to get her out if we get that option.
Okay.
Thank you for coming.
I'll work on that.
Thank you, sir.
And I contacted DCF, and they're not going to do anything if she's in jail. I mean, they're not even going to come interview or anything. So I still think the solution is the sheriff's office has to wait till the DCF shows up. So, and
Mr.
they won't come out of here.
Mr. McDaniel, if I were to release her, I can't release her to DCF custody because they haven't accepted custody of her, and there's no court order, right?
Correct. I mean, no, if there was no criminal charges and the sheriff's office had no place for her to go and she was an elderly person like that, they would call and they would have to wait until TCF shows up.
I don't know. You think your impression is if you have an elderly person and the sheriff's department's involved, let's just take the criminal case out of this equation for a moment. There's an elderly person and there's no one to care for them, that DCF will accept responsibility and find a placement for them. That's your understanding of the law?
Correct. That's my understanding. I'll try to find. I don't know case law on it, but I mean that's what they're there for, is to help minors and elderly and
I don't know. The Department of Children and Families, I don't know if they have the ability or the mandate to find placement for individuals. If that were true, we wouldn't have a homeless crisis. I just don't know that that's accurate, Mr. McDaniel.
Yes, sir.
I don't know. I've never seen it. I mean, we've got a lot of people that need placement.
Correct. It is, and it goes to where if they're in danger. Now, if they're not in danger and if they're not incompetent, and that's what a lot of the ones that you see are homeless are like. Yeah, they're not in danger, they're not incompetent. But if someone that can't walk and is bedridden, that's in hospice care, I mean that's a little bit different. Okay. And I think that's a little bit different on that scenario, and I think that they would have to come in and try to find some place to. Normally, what they would do is try to talk to family members, and I'll be honest with you, they will twist arms, family members, to try to get them to take them. That's how they would handle most of those situations. But when everything else, they can't do anything, they would have to be responsible to find some place to take her, which may be a hospital, and let her sit there at the hospital, until they can find something.
And I think in this case, she was in the hospital, and then she was released from the hospital, and that's when all this happened, right?
Yes, sir.
Okay. Well, thank you, Mr. McDaniel, for trying to find her a place, Mr. Mitchell, and thank you, Dr. Hudson, for coming today.
Thank you.
Thank you, sir. All right, so Mr. McDaniel, that's everything I had on my first appearance list this morning. Have I missed anything, sir?
No, Your Honor.
Corporal, what about from the jail? Anything from the jail?
Nothing from jail, sir.
And Mr. Mitchell from the state?
Nothing from the state, Your Honor.
Is Monday an arraignment day?
Yes, Your Honor.
So I'm trying to think ahead. We've got we're going to have 4 days of possible first appearances that we need to see, the ones that at least misdemeanors that we can make an offer in. How big's the docket for Monday? Well, it's not bad at all.
Pages.
So if it's only 25 cases, we should have time, Mr. McDaniel, to see everybody we need to see and make any offers we need to make and still do a full arraignment day or half a day, whatever it's set for. All right. Well, thank you. Hope you have a great weekend, a great holiday.
Go off YouTube just for a second.
Sure. Ladies and gentlemen, that concludes first appearances. We're going to go off of Zoom and YouTube. First appearance for.
Alrighty, friends. Well, he moves on with his day. Doesn't sound like we're going to see him again until Monday. We are, by the way, going to try to put together a show on Black Friday, which should be fun. But I wanted to take a moment. We have a new sponsor here for the channel, and that's this right here, the company called Cremo. Now, I reached out to Cremo because I've been using Cremo for years. People always ask me all the time, Dan, how is it at your advanced age that your skin looks so good? Why is it that your face is always so nice? Your beard is so beautiful, despite only having like 5 or 6 hairs left on the top of my head. How do you look so good? Well, the truth is I've been using Cremo, and I've been using Cremo for years. And this is true. I refuse to endorse a product that I don't believe in and haven't used myself. And I've been using Cremo for years. So Cremo does a lot of face and body care product. They have body washes, they have beard oils and creams, and this particular shave cream, which I use, is just wonderful. This stuff, it even says on the bottle 90-day supply. I get a little over 100 days out of it, actually. The amount that you need is very little. I have no razor burn or anything whatsoever, and I do shave because I have to shave around the shape of my beard. Their beard oils are tremendous. Everything is good, and they've got stuff for the ladies, too. So get yourself a little something nice. Get something for a Christmas present for somebody. TCFhub.com/Cremo. That is TCFhub.com/CREMO. Support the people that support the channel, and honestly, this is just a really good product. Again, I've been using it for years, so give it a look. Again, TCFhub.com/Cremo. There is a link down in the description. Let's go. Let's check in on Glazer. How's she doing today?
This is the allocation. I'm pretty sure DCF's going to get involved. They'll place her somewhere, either a relative or a foster or a shelter home, excuse me. And so that's up to them. Right now, there's no criminal proceeding against your daughter. You're the one who's charged with a criminal offense. So you got to do whatever juvenile says, the dependency court says regarding your contact. That's how I'm telling you. You understand? Just stay away from.
Well, yeah, we're under the same roof. That's my daughter. That's why I'm asking questions. It's just me and my kids. So to stay away order was, I called you guys. I'm the one.
So they're probably going to remove her and take her out of the home and place her somewhere else. Do you have other children in the home?
Yes, she's my oldest daughter.
Well, you better not use any excessive corporal punishment towards your younger children. You can't bite your children. You shouldn't be strangling them, choking them. These are allegations. I'm just telling you. I understand. I got a girl. I know what it's like, okay? But you can't use violence when you're disciplining a child. So that's why you got arrested. So whatever they say in dependency court, you have to do what they say with regard to visitation. Do you understand?
Well, yes, the first time I'll get.
It's fine. I'm going to give you trial services for the alternate bonds. I'll set it at $3,000, so you can get out of jail for free. Just make sure you keep all future court dates and keep whatever court dates in dependency court. You're going to be contacted by a protective investigator from the Department of Children and Families. You want to reach out with them, and they can still offer you assistance with your younger children if you feel overwhelmed. Okay?
Yes.
All right. Have a nice day.
And she also has a dollar bond on DWLS knowingly.
All right. Include with trial services. I'm sorry. I need a ticket number, please. I don't have it.
A is in alpha, L is in Lima, X as in X-ray, X as in X-ray, I as in India, M as in Mike, E as in Echo.
Okay, it's DWLS with knowledge.
Yes, Your Honor.
So include with pretrial services, the DWLS with knowledge, ALXXIME, alternate $1. Have a nice day, man.
So Judge Glazer doesn't sound like she's doing too bad, but once again, her audio is already on vacation. Go figure. Let's go back to Michigan, but let's spend a few minutes with Judge Mom.
Your Honor, good morning. Well, P 30758 yes, yes. Your Honor, the time set for arraignment and pretrial in this particular matter. As to the pretrial, you would stand mute to, I'm sorry, as to the arraignment, you would stand mute to the charges, waive a forming of those charges, and ask for the plea of not guilty.
All right, here in the court will waive the formal reading, enter plea of not guilty for purpose of the arraignment. As to the pretrial.
As to the pretrial, Your Honor, at this time, it's my understanding that in return for a plea responsible to, to a double parking, as well as to a expired plate, the original charges would be dismissed. Constitutional rights. He understands those constitutional rights, wishes to enter into this plea opportunity, and there are no immigration issues.
All right, sir, please raise your right hand. The other right hand. The other right hand, thank you. Do you solemnly swear or affirm testimony you're about to give in this matter to be the truth, the whole truth, and nothing but the truth?
Yes.
And you heard the plea that was placed on the record, correct?
Yes.
As to the amended charge of double parking, how do you plead?
Responsible.
Okay, you may already, yeah, thank you. As to the amended charge of expired plate, how do you plead?
Responsible.
You've gone over your advice of rights with your attorney, correct?
Correct.
And you understand all of those rights?
Correct.
And you also understand the possible penalty as a result of your plea, whether in this court, any other court or administrative agency. And knowing all of that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Any immigration issues?
No.
All right, the court will accept the plea as knowing and voluntary. It's $200 for double parking, $100 for the expired plate, and the original charges will be dismissed. That's a total of $300. Do you have that to pay today, sir?
Yes, I'll pay him for
All right, please stop at the window. Somebody will be with you shortly.
it. Your Honor.
Have a good day. Thank you.
Thank you.
And we are on the record in the matter of the city of Wyandotte versus Nicole Weems, 251269.
Good morning, Your Honor.
Good morning.
Your Honor, John Goldblatt, P 30758, on behalf of Ms. Weems. Ms. Weems, please put your name on the record.
Okay, Ms. Weems, you're on probation with this court.
Yes.
And yet, here you are. Counsel, as to the arraignment.
Your Honor, as to the arraignment, she stand mute to the charge, waive a formal reading of those charges, ask that a plea of not guilty be entered on her behalf.
The court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment, and as to the pretrial.
As to the pretrial, Your Honor, I've had an opportunity to discuss this matter with Ms. Weems. I've also discussed with her the fact that she is on probation and that this would have an adverse effect, entering into some sort of plea with respect to that. But knowing all of that, she wishes to avail herself of the plea that's been reached. My understanding is in return for a plea of guilty to operating while impaired, the people would move to dismiss the original charge of operating while intoxicated by BAC. Explain to her constitutional rights and explain to her the rights that she would be waiving by entering into this plea agreement. She wishes to avail herself of this opportunity, and she does understand those constitutional rights. Is that correct, Ms. Weems?
Yes.
And there are no immigration issues.
Please raise your right hand, ma'am. You solemnly swear or affirm testimony about to give in this matter be the truth, the whole truth, and nothing but the truth.
Yes.
And you've gone over your advice of rights with your attorney, correct?
Yes.
As to the amended charge of operating while visibly impaired, how do you plead?
Guilty.
You've gone, and you understand the rights that you've gone over with your attorney, correct?
Yes.
And you understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes.
You do understand, ma'am, that this is likely going to trigger a probation violation, correct?
Yes.
And knowing all of that, do you want to continue with your plea?
Yes.
I can't hear you.
Yes, ma'am. Sorry.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Any immigration issues? I'm sorry?
No.
Counsel, if you can please pardon your client.
Ms. Weems, on August 25th of 2025, you were operating a motor vehicle in the city of Wyandotte.
Yes.
And there come a point in time where you came into contact with some Wyandotte police officers.
Yes.
And prior to coming into contact with those Wyandotte police officers, were you consuming alcohol?
Yes.
And
Ma'am, you need to keep your volume up, okay, please?
what were you drinking?
I had a bit of bourbon.
You had a bit of bourbon.
Yes.
Would you state you had quite a bit of bourbon?
Yeah.
Okay. And when you were seen by the police officers, they gave you some certain field sobriety tests. Is that correct?
Yes.
And eventually you were detained and you took a PBT as well as a breathalyzer test. Is that correct?
Yes.
And the results of that breathalyzer test were 0.1
.184.
and 184. Is that correct?
Yes.
Okay, the other one too. Thank you, Your Honor. Defense is satisfied, Your Honor.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. And the court will accept your plea, your very generous plea that you were provided, ma'am, and dismiss the original charge per the plea agreement as to bond counsel.
As to bond, Your Honor, Ms. Weems has complied. She's appeared here today. She's gainfully employed. As the court is well aware, she is on probation to this court. This was obviously when we spoke to her. When I spoke to her, I informed her that this would be a violation of that probation. She understood that. She told me, when I questioned her, what was going through your mind, she said it was just a real bad day and that made it worse. So I'm just indicating that to the court. I'm asking that she's accepted responsibility for this incident as well as a probation violation by entering into this plea at this point in time. We're asking for a personal bond as she gets ready to go for sentencing.
So ma'am, you've had a lot of real bad days, it appears, in this court, because your matters date back all the way to 2022. In 23, failed to display a license, allowed an unlicensed driver to drive. That was as a result of a driving while license suspended. Another driving while license suspended, plate violation, possession of paraphernalia, which is what you're currently on probation for, and now you have a high BAC. You're not allowed to drink alcohol on probation anyway, ma'am. Yet you did it anyway. Well, we're gonna test right now what's in your system. When's the last time you consumed any alcohol?
That night.
Where do you work?
Right now, I just got a new job at, it's called Baker's Life. It's a life insurance agency.
Well, given the fact that you're on probation for possession of paraphernalia, and you've completely disregarded the conditions and orders of this court for probation purposes, the court has concerns that you're going to disregard its orders of bond. To ensure that you're not going to do that, the court's going to order a $5,000 10% bond. You're not to possess or consume any alcohol or drugs unless prescribed, which you're already not allowed to do because you're on probation. And then you are not to be released without an alcohol tether through the Wayne County Jail.
Your Honor, can she be able to post it, make arrangements, rather than going to Wayne County Jail to obtain the tether
Yeah.
here, if that can be posted? Instead of through the Wayne County Jail, the tether.
There's no talking in court. If you want to have a conversation, go out into the lobby, sir. No, your client's being taken into custody. She's not going to be released until she has the Wayne County Jail alcohol tether.
Thank you.
So you're going through this door today, ma'am. You want to have a conversation with your work that you won't be there.
When she's released, you then understand too. Wait. It's time to speak today.
Okay, ma'am, you can step out into the lobby because you and your person next to you continue to talk. That's why you're out in the lobby. Counsel, I indicated that your client's taking the ride down to Wayne County Jail to get the tether.
I understand, Your Honor.
Yes.
And then when she's released on the tether, she will then have to appear for.
Oh, for a PSI, yes.
What I was.
I'm sorry, I didn't understand
what you were saying about going to Wayne County. Yeah.
Yes.
I was just confirming what she's to do once she.
Yes. Yes.
Okay. Thank you, Your Honor.
All right, thank you. Have a good day. We're on the record in the matter of the city of Wyandotte versus Jamie Singleton, 2548. All right, and counsel?
Your Honor, John Goldfarb, P 30758 on behalf of the city. Please put your name on the record.
Okay, and so good morning. Today is the date scheduled for the Pretrial, your client had previously failed to appear in June. Then a warrant was issued. She ended up in custody in November. And the court had arraigned her November 12th, set today's date for a pretrial, and your client posted the $2,500 10% bond.
That's correct, Your Honor. Your Honor, I have had an opportunity to discuss this matter with Ms. Singleton. I've also had an opportunity to discuss with her the reasons why she's on an alcohol debit. I'm not an alcohol debit, out of another matter, as a detainer, as a witness detainer. That proceeding is scheduled for some time in December 1st. I have discussed it.
Which court is that in?
Pardon?
36th district.
Okay.
I'm sorry, Your Honor. And so as of today, she's already pled on the not guilty. This is a pre-trial. I discussed this matter with the prosecutor. It's my understanding that Ms. Singleton would plead guilty to the charge of drug paraphernalia with the understanding that there is a recommendation and only a recommendation of time served plus costs and fines in this particular matter. With that said, Your Honor, she wishes to avail herself of this plea opportunity.
Please raise your right hand. Do you solemnly swear or affirm testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
And you heard the plea that was placed on the record, correct? As to the charge of possession of drug paraphernalia, how do you plead?
Guilty.
And you've gone over your advice of rights with your attorney, correct? You understand all of those rights?
Yeah.
Are you picking her up, Allie?
Yeah.
Okay. And you also understand by entering into a plea that you'll be waiving some of those rights.
Yes.
You also understand the possible penalty as a result of your plea, whether in this court, any other court or administrative agency. You understand the recommendation is for fines and costs only and credit for time served, but that's only a recommendation.
Yes.
Knowing all of that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Any immigration issues?
No.
And counsel, if you can please order your client.
Ms. Singleton, back on April 7th of 2025, were you in an automobile with a Mr. Cosmo?
Yes.
And there was a traffic stop.
Yes.
He was the driver of the car.
Yes.
Is that correct?
Yes.
And during the traffic stop, one of the police officers talked to you and at one point in time asked you to step out of the vehicle. Is that correct?
Yes.
And you did step out?
Yes.
And then they asked if they could search you. Is that correct?
Yes.
And you consented to that search.
Yes.
Is that correct? And during that search, they found Shore Boy and drug paraphernalia on you. Is that correct? And you knew that you were not supposed to possess drug paraphernalia. Is that correct?
I was unaware of them in bargain.
But you did
Yes.
possess it.
Yes, I did.
Defense is satisfied, Your Honor.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the charge, and counsel as to sentencing.
As the sentencing, Your Honor, I would ask for, she did do 8 days. 8 days on this particular matter. Subsequently to this case, she does have some prior contacts. I don't believe that there are any drug contacts. There may be paraphernalia or something, but there's no drugs. We're asking for costs and fines in this particular matter. She can move along, go be a witness against somebody in the 36th District Court.
Ma'am, if you're to test right now, what's in your system? When's your next date? Your next court date, December 1st?
Yes, ma'am. I'm having Jim meeting at 7.
Okay, now Carlos Cosme is here. Is he any relation to Jose?
He's, no.
Just happened to
I
be
don't
here.
know him.
Okay.
Oh,
That's probably where
Oh,
he's
okay, yeah.
taken. Yeah, no. He was the driver of the car. He paid my bond. I don't know if that has anything to do with it.
Carlos?
No.
no,
Jose.
Okay.
was it? Oh, I'm sorry.
$100 fine, $100 cost, crime victim assessment fee of $75, justice system assessment fee of $50. which is a total of $325, is a $50 probation, warrant fee. So that total is $375. The court's going to also order, when did you post bond, ma'am?
I think it was like a week ago. I'm not sure what date it was.
Well, how do I know how much time to give her credit for, counsel?
What date it was, I'm not sure. I don't need my bond paper with me.
Well, you should have probably brought that so I can give appropriate.
When did you get out of Wayne County Jail?
I'm sure. I think it was like a week, 2 weeks ago. I don't remember the date.
Ma'am, do you not keep track of dates or days?
Well, yeah, I think it was on a Friday.
A Friday.
I think it was, yes, it was.
So would that have been this past Friday?
2 Fridays ago.
Excuse me. This past Friday of November 21st or the prior Friday of November 14th?
November 14th.
So then your client was only in custody for 2 days. On this case anyway, she may have been in custody on another case, but she was arraigned November 12th.
Okay.
Okay,
So I'll give her credit for 2 days.
thank you.
I did have a bunch of cases.
Right, so I'm not giving you credit for all those other days.
Thank you, Ron.
Do you have that to pay today, ma'am?
No, ma'am.
I think there was,
Where do you work?
there was a bond posted in her name, Your Honor.
Yeah.
No, I think Mr. Cosme posted it.
I don't have a job, ma'am.
Well, how do you support yourself, ma'am?
I have he's been helping me. My boyfriend.
How do you support yourself? When's the last time you worked?
It's been a couple of years.
Why don't you work?
I had.
Well, obviously.
Yeah.
Why don't you have a job?
I don't think.
Well, look, because I'm giving you 45 days to get this paid.
Yes, ma'am.
Friday, January 16th. Paid in full.
Thank you. Thank you, Your Honor.
You have a good day. We're on the record and then, oh, no, Mr. Westmoreland's everywhere.
Sorry, Your Honor.
She has a question for you.
Oh. Go to the front window and I'll tell you how to pay.
We're on the record, the matter of the city of Wyandotte versus Tawana Buckner, 251299AB.
Morning, Your Honor.
Good morning.
Your Honor, John Goldpaw, P 30758, on behalf of Ms. Buckner. Ms. Buckner, please put your name on the record.
Okay, good morning, and please keep your hands out of your pockets. And today's date scheduled for the arraignment and pretrial in this matter. And counsel?
As to the arraignment charge, you state. No, those charges asked that a plea of not guilty be entered.
All right, the court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment. As to the pretrial, counsel.
As to the pretrial, Your Honor, I discussed this matter with Ms. Buckner as well as with the prosecuting attorney. Like saying that in return for plea of guilty to no operator's license on possession and responsible to the expired plates that the driving while license suspended as well as no proof of being responsible to no proof of insurance. I may have said expired plates, but it means that the driving while license suspended, the no insurance, and the expired plate. Explain to her constitutional rights. She understands those constitutional rights and understands that by entering into this plea, she'd be waiving some of those constitutional rights. Knowing all of that, she wishes to avail herself of this plea opportunity, and there are no immigration issues.
Okay, I'm going to please raise your right hand. You solemnly swear or affirm testimony about to give in this matter be the truth, the whole truth, and nothing but the truth.
Yes, I do.
Okay, are you picking our Bailey? I need you to speak up louder, please.
Yes.
Very good, thank you. And you heard the plea that your attorney placed on the record, correct?
Yes.
As to the amended charge of no operator's license on person, how do you plead?
Responsible.
No, that was going to be,
No operators is good.
Yes.
okay. As to the amended charge of no proof of insurance, how do you plead?
Yeah. Responsible.
And you've gone over your advice of rights with your attorney, correct?
Yeah, ma'am.
And you understand all those rights.
Yes, ma'am.
You also understand by entering into a plea that you'll be waiving some of those rights.
Yes, ma'am.
You've gone, you understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes, ma'am.
Knowing all of that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Any immigration issues?
No.
And counsel?
Thank you. Ms. Buckner, on September 3rd of 2025, were you operating a motor vehicle in the city of Wyandotte?
Yes.
Did there come a point in time when you came in contact with the Wyandotte Police Department?
Yes.
When they asked you to provide them with a valid driver's license, you were unable to do so. Is that correct?
Correct.
So you did not have a valid operator's license on your possession at the time you were operating this motor vehicle. Is that right? That's satisfactory.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. And the court will accept your plea to the amended charges, dismiss the original charges per the plea agreement. And ask Chief Sentencing Counsel.
Mr. Sentencing, Your Honor, we'd ask for immediate sentencing in this particular matter. Ms. Buckner has one more matter to take care of. It's in some place in God's country. Attica, Michigan. She's been in contact with them. Yes. It is trying to set up a plan to get that matter set aside or solved so she can have her full and complete life. She was driving this day. She borrowed somebody else's car because she had to get her 4-year-old son to get to a dentist appointment that she had for quite some time. She clearly understands this within the state. She's gainfully employed. She's single. She has 4 children.
Okay. So, ma'am, how'd you get here to court today?
I Ubered.
How much of that set you back?
Like $38.
And she's been here early, Your Honor, so
Yeah.
I understand. She's the only one that's being called early today, I'm gonna guess.
I understand, and right, just saying that because she wants to get this and we get responsible.
And how do you get back and forth to work, ma'am?
I Uber or I ride with one of my coworkers if we're on the same schedule.
And how do your kids get to and from school?
They get on the school bus.
All right, and how do you owe money up in Attica? You already know how much you owe? You have
I
to go up to court.
No, I made a court date with them. I didn't contact them. I had to go up there to the court and then they had to do my facts and things that day.
Okay. All right, so the court's going to order a $100 fine, $100 cost, crime victim assessment fee of $75, justice system assessment fee of $50 on count on the no ops. So that's $325. And then you have the no proof of insurance is $175 for a total of, it looks to be $500 even. How much can you pay per month? And what day of the month works best for you?
My pay is bi-weekly, so I would say maybe $100.
Okay,
Okay.
and when can you begin that?
I get paid on Friday this week, so starting Friday this week.
Okay, beginning December 5th?
Yes.
Okay, if you'd like to stop at the window and get information about paying online, you can certainly do that. Okay?
Thank you very much.
All right, good luck to you, ma'am.
Thank you.
Have a good day.
All right, we'll keep an eye on Judge Mom, but let's change it up. We'll stay in Michigan, but go to St. Joseph County, spend a few minutes with Judge Middleton today.
Mr. Stainer, your lawyer, Mr. Truckee, was scheduled to be here this morning, so I asked him to address this matter as well. I'm going to put you in a private space in what's called a breakout room where you can talk to him privately.
Okay.
So he's opening that room right now, and we will set that up. I thought the prosecutor wanted to be present, and they're not able to be here yet, so we may need to wait a minute as it is.
Yes, sir. Yes, sir.
All right, I'm going to open the breakout room. You may have to click the button that says join. I don't think it does it automatically, but I'll let you talk privately with your lawyer.
And just as quickly as I go there, we need to leave because they're going into a breakout room. Let's go back to, let's go to Lake County, new contestant for Judge Collada.
Thank you, Judge. We're here in case number 25 CR 1546, caption State of Ohio versus Jeffrey Liebach. Judge, the defendant was indicted by the Lake County Grand Jury on November 25th of 2025. With one count, the charge of possession of cocaine, a felony of the 5th degree, violation of ORC 292511, and attached forfeiture specification. Defendant is present in court today with counsel, Ms. Smith. It is the state's understanding that we are here for purposes of in-court arraignment.
Ms. Smith?
Thank you, Your Honor. We are here for the purpose of in-court arraignment. Mr. Liebach is in receipt of his indictment and has been for more than 24 hours. He respectfully waives reading of the indictment as well as advisement as to penalties, enters a plea of not guilty, and asks to be heard on the bond motion previously filed by assigned counsel Chad Mulkey.
I ruled on that already.
My understanding is that we are here to ask the court to reconsider its ruling.
Well, I mean, we're here to set bond. I mean, that motion's been ruled on, but arraignments for purposes of setting bond, so you can make whatever.
So we would like to be heard as the bond.
That's the way I think it's best to handle that. Thanks. Mr. Liebach, you received a copy of the indictment?
Yes, sir.
Had a chance to look it over?
Yes, sir.
You have the right to have me read it to you if you want. I could do that, or you can waive the reading. What would you prefer?
You can waive the reading.
Very well, then ask the one count of possession of cocaine, a felony of the 5th degree, forfeiture specification. What is your plea at this time?
Not guilty.
All right, the court will enter a plea of not guilty. Answer the manner of bond. Ms. Neroda, what's the state's position on bond?
This state would request that the bond remain revoked as the defendant tested positive at the Willoughby Municipal Court level, and we would ask that revocation stand.
So we had a bond at Muni Court. They had a urine screen and came back positive. Yes. For what, do you know?
I'm sorry, Judge, I tried to find out.
And the bond was revoked in the Muni Court then because they didn't comply with the bond conditions?
Yes, that's correct, Judge. According to the Muni Court docket, it was revoked. And it may be at the request of a prosecutor's motion filed, but I was unable to obtain a copy of that.
Ms. Smith? Going to be heard on bond?
Yes, Your Honor. We are asking the court to consider setting a bond for Mr. Liebach. He does acknowledge and acknowledged in Willoughby Municipal Court that he would test positive prior to being submitted for a urinalysis. He indicates that he tested positive for THC, alcohol, and cocaine. Your Honor, Mr. Liebach does own his own landscaping company, as most landscaping companies do. At this time of year, they plow. He has a number of contracts that he will be unable to fulfill if he does continue to stay in the Lake County Jail. He also does firewood supply and has contracts with several stores and provides firewood for the elderly. He is the sole individual responsible for the mortgage at his home where he lives with his fiance. Mr. Liebach acknowledges that he has a substance use disorder and has scheduled an assessment for December 3rd with Lake Geauga. Additionally, Your Honor, Mr. Liebach has a heart condition. He did have a cardiac incident in the jail and would like to follow up with a cardiologist on the outside. He has been in the jail with his bond revoked for 21 days at this time. So, Your Honor, in light of his responsibilities on the outside, the time that he has spent in the jail, and the efforts that he intends to take to remedy the issue underlying his bond revocation in the first place, he is asking the court to set a bond equivalent to that which was set and posted in the municipal court.
Well, I understand he's got these responsibilities, at least according to you, according to him. Then why is he putting himself in a position to not be able to fulfill those responsibilities? He was given a bond. You were given a bond. You're told you can't use drugs. If you use drugs, your bond's going to get revoked. And you went ahead and used drugs anyway. So you have all these responsibilities, these people relying upon you, medical issues, all the other things your lawyer said. And you went ahead and put yourself in the position, said, well, I'm still going to go ahead and use. put myself in that position where I can't fulfill those, and now I'm supposed to take that into consideration when you did it. And I understand that you have an addiction problem, it sounds like, from what your lawyer said, but you think you're just going to be able to walk out of here today and without having addressed that at all, and you're going to be fine? You couldn't do it when you were on bond the first time.
I'm seeking help.
Seeking help, you have an appointment for next week,
Those
and that's not just going to an appointment doesn't magically cure you.
I understand that.
So what's going to be assuring me that you're not going to use? You couldn't abstain from using when you were on bond the first time when you were.
I mean, I can report, or if you guys can give me an ankle monitor or something like that, you know, I plan.
If you have the ability to do that, then why didn't you do it?
I don't know. I don't have a good answer for that. I made a mistake, and I'm working.
So it's a condition of your bond, and you didn't do it. So why should you get the benefit of being able to have a bond again?
I'd like another opportunity.
Why? Why do you deserve that?
I feel I deserve a new chance. I'm trying to make a new name for myself. I'll do anything it takes.
Sorry?
I said I'll do anything it takes.
Well, Mr. Lebeck, I will reinstate your bond at $5,000, 10%, with the condition that you report to the probation office at least once a week, if not more.
Okay.
It'll be up to, and you're going to provide a urine sample each time. It better not be tampered with. It better not be fake. It better not be someone else's. It's going to be a monitored screen that you're going to come
That's
in,
fine.
and someone's going to watch you go to their bathroom.
That's fine.
Now, you say that. I don't want to. Your words don't mean anything. Your actions will mean something.
Yes, sir.
If you test positive one time, your bond will be revoked, and it will certainly not just land you in jail pending the rest of this case, but it's certainly going to be something that's taken into account by whichever judge gets this case, that you've been on bond twice with conditions of not using, and you couldn't even comply with that, which will be, in a sense, a preview of how you will do or not be able to do on probation if you were to be given a chance of probation. So,
yes, sir.
It's more than just being able to remain free. It's going to have a lot to do with what you're, assuming this were to end up in some type of conviction. You have a right to a trial, and I'm not saying that you're guilty of this charge or anything along those lines. But if you were to ultimately be found guilty or plead guilty to a charge here, you're going to be asking for probation. That's something that's going to be taken into consideration as well.
Yes, sir. Thank you.
So you're going to get out sometime today, however long it takes them to book you out. Before you leave, you need to go to the probation department, which is in the same building. You know where it is?
Okay.
You know where it is?
I do not.
All right, so when you're at the jail, you're going to come down that one side, and you're going to walk to the front doors, and then to the other side, there's elevators there. You're going to go up that side of the building. So you're not even going to leave the building.
Okay.
Your lawyer will explain it to you. It's the third floor. You're going to go up there, going to meet with them. All right, is there anything else for the record, Ms. Naroda?
I think, Chair, do I need to do any additional
No.
entries? Okay, thank you, Chair.
Smith?
Not at this time, Your Honor.
Thanks.
All right.
Judge Collada is a happy man this morning. He's, as Michael mentioned earlier, he is definitely channeling his inner Judge Glazer. So we'll keep an eye on that court. Let's go to Wexford County, Michigan. We'll say good morning to Corey Wiggins.
People of the State of Michigan versus Nicholas Iman. We are here for a pretrial conference who appears on behalf of the prosecutor's office.
Joanna Carey for the people.
All right. Mr. Iman, you had requested a attorney in this matter. And for whatever reason, the public defender's office has a conflict, so they've sent it to the conflict attorneys, and nobody has been appointed yet. So what we're going to do is we're going to set this over for another pretrial. It'll be set for next week, and we'll see if somebody picks up the appointment by then.
Okay.
Now,
You're released on Friday.
you get released on Friday? All right.
Email from the conflict administrator that the person Tawa has been appointed. I don't have anybody. I sent on November 12th to commit to Wolnick, Ms. Wright, Ms. Luzinski, Ms. Colvin, and Ms. Payne.
Let us
I don't
check.
have anything. I never got an appearance from them, but I do have.
I have it from Sierra saying it went to conflict and overflow. That was my last.
Any paper.
Well, and you wouldn't, because it would come through your attorney.
Right.
So, and so far, so Ms. Carey is saying she's received an email saying that one has been appointed, but that attorney has not filed an appearance yet with the court.
Yeah.
So,
Can I just represent myself in this matter? It's a small matter.
well, that's up to you.
It's
I
a
mean,
small matter.
you have the, so you have the option to represent yourself. You requested the appointment of an attorney.
Yeah, well,
So-
I don't have to do this, so like, can I just represent myself and do the
So
in the training, sir.
in order to do that, there's a process we have to go through. So I have to make sure that your waiver of an attorney is knowing and accurate. So I have a form I need to read to you. So before we start that form, how many years of education do you have?
I mean, I'm not graduating.
How far did you go?
11.
11th grade. All right. So this form says that I am the defendant in this case. The judge has explained to me, and I understand that I have been accused of a crime, and I have read or have read to me the charges against me, and know the minimum and maximum possible sentences, the nature of the charges, and that there may be a lesser included offenses, defenses, or mitigating circumstances. That I had the right to be represented by a lawyer at all stages of the process, and the court will appoint one for me at public expense if I cannot afford one. That I had the right to consult with the lawyer and the lawyer that I hire or that the court appoints. That I had the right to act as my own lawyer. That if I represent myself, I will be held to the same standards of law and procedure as a lawyer and will not get any special treatment from the court. The risks of being my own lawyer, including that a lawyer has skills and expertise that I do not in preparing for and conducting a criminal defense and trial, and that the state does have an experienced lawyer. Unlike the prosecutor in this case, I will be exposed to the dangers and disadvantages of not knowing the complexities of jury selection, procedure, or how to preserve my appeal rights. That because of these things, it can be unwise to act as my own lawyer. I knowingly and freely waive my right to the assistance of an attorney and choose to represent myself. I do not want to hire an attorney or have the court appoint one for me. I have no doubt about my decision. I have 11 years of education. I read and understand the English language, and I am mentally sound. Do you agree with all that? And knowing all that, do you still wish to represent yourself?
Yeah.
Okay.
That's why I give you
All right.
the ball, man.
Bailiff, can we have him sign that, please?
Yes, sir.
Ms. Carey, do you want a moment to speak with him?
We can have this, they'll do it, and we can keep moving.
Okay.
Yes, sir.
Parents thing because she gets appointed, but we never have appearances.
Okie dokie, forgive the little pause there. I was tending to about 7 things at once. Let's go back to Judge Middleton now. That defendant who was put in the breakout room is back.
All right, we had an emergency matter I tried to do at 9 or 10:45, which I should have known better. We got sideways for a couple different reasons. And that is in the matter of Caleb Evan Stainer. Mr. Stainer, we're right in the middle of lunch hour. Try to get you back to it. Mr. Stainer is presently in the St. Joseph County Jail. He had previously posted a $2,000 10% bond and a charge of domestic assault. It was a condition of his bond that he not have any contact with the complaining witness in that case, and her name was Mariah Baldridge. He also was not to use any alcohol or engage in any assaultive or threatening behavior. He got arrested early this morning, about 12:30, and it came to my attention first thing this morning. He has an attorney pretrial set for next Friday, December 5th, on this charge with attorney Ross Truckee. Mr. Truckee was scheduled to be here, so I attempted to schedule this before we started our other sentences. Anyway, Mr. Truckee is here, and Angelique Campfield is here from the prosecutor's office. This is very troubling information. If the information is correct, you went to Ms. Baldridge's house in violation of the order, assaulted her, fought with the cops, and are facing some new charges. Ms. Campfield, do you have any input on this?
Yes, Your Honor, I do. As a matter of fact, the defendant has been charged with additional offenses by Mr. Robar from my office this morning pertaining to the conduct alleged last night: home invasion in the second degree, aggravated stalking, interfering with a crime report, and another charge of domestic violence. It is very pertinent to note that at least after speaking with both the defendant and the protected party in this matter, the officers did see new, fresh injuries on her consistent with the version of events that she provided. And again, what the court's already stated is most concerning is that this is in violation of a protective bond for a pending domestic violence charge, where she again is the alleged victim and the protected party. He did have a 0.24 preliminary breath test, although he stated to the officers he felt he was only a 3 on a level of 1 to 10 for intoxication. It's extremely concerning. She's not safe when he is on bond. He is violating this court's orders blatantly, not only contacting her, but committing new alleged offenses, injuring her, and then additionally consuming alcohol as if the court's order makes no difference to him. I think that it is necessary to set at this point, I request $100,000 cash or surety bond, or even a bond revocation. We've got new serious felony offenses pending as alleged from last night, and a protected party who is not safe when he is in the community.
Mr. Truckee?
Mr. Stainer would deny all of the allegations in the bond report and enter the equivalent of a not guilty plea to any kind of contempt proceeding.
All right, thank you. Mr. Stainer, you've got a lot of anger. We had that incident a few years ago where you allegedly assaulted Jack Brandt. He's charged with aggravated assault. That was a very unpleasant case. I think ultimately got dismissed. And then we have this other domestic violence that's presently from November 13th. And on November 26th, 13 days later, you're even worse.
If I can say anything for myself.
Well, don't say anything at this point. I'm gonna cancel your bond. You'll get arraigned on the new charges. Now, the new charges are felonies punishable by up to 10 years in prison. So you didn't improve your situation much. Now you're charged with some more serious offenses. Bond canceled, can have further hearing. Regarding the allegations on 12/5/25 at APT. You got a court date next Friday anyway. You need to be right where you are. You're a danger to your girlfriend, you're a danger to the public, and you're a danger to yourself. So Mr. Truckee will have more time. You know, I thank him greatly. He didn't know. I found out about this at 7:45. He found out about it at about 9:30. In the meantime, you're going to stay where you are. And next Friday, we'll have more chance to address this and your new charges. But
Yes, Your Honor.
we would all look very bad if someone had died as a result of this. All right, you can go have lunch. I'll see you next Friday morning with your lawyer.
Thank you.
Thank you.
Thank you, Your Honor.
Okie dokie. Let's go to Reno. Judge Shelley O'Neill. That's always a good time.
Room, so you can go over the restitution information with your client, Mr. McGinnis. Does that work for you, sir?
Please, thank you, Judge.
Your Honor, I'm placing both you and Ms. Giannoli in the waiting room.
Mr. Riza, can you hear me?
Señor Reza, ¿nos escucha?
Sí.
Yes.
The court is wanting you and I to have a conversation about restitution.
La jueza quiere que usted y yo tengamos una conversación acerca de la restitución, acerca de la compensación.
Restitution is a term the courts use to make a victim whole when there's damages.
La restitución es el término que utilizan el tribunal para poder recompensar a la víctima por los daños que él o ella haya podido sufrir.
They are recommending $3,787.29 in restitution.
Están recomendando $3,787.29 como restitución, como compensación.
That's for the damages to the vehicle.
Esto es para pagar por los daños del vehículo. The other vehicle, right, Patrick? The victim's vehicle.
Yes.
El otro vehículo, señor, el vehículo de la víctima.
Do you understand that?
¿Entiende esa parte?
Sí, sí la entiendo.
Yes, I do understand.
Do you agree to pay $3,787.29 in restitution?
¿Está de acuerdo entonces en pagar $3,787.29 como compensación, como restitución?
Es que tengo una pregunta.
I have a question.
La corte pasada, no sé si me dijeron que habían quedado de acuerdo en pagar el deducible, que eran $1,000, pero no estoy de acuerdo si así o no.
Sí, un momento. So, Patrick, he's mentioning at a prior hearing, at some point, somebody mentioned about a deductible and paying a deductible that is only $1,000. There were some talks about that. Is that still the case, or?
I'm looking at the bill right now, and it looks like insurance is paying $2,000 only, and the balance is $3,787. The total for the bill is over $6,000.
Okay.
So insurance is paying almost half.
Señor, lo que está diciendo el abogado es que la aseguranza está pagando como unos $2,000, el pendiente son como $3,787. Parece ser que el total de todo fue como $6,000 y pico, y que la aseguranza está como pagando como un poquito menos que la mitad.
Ok, ¿y cómo sería eso del pago? Porque ahorita pues, estoy, no sé si me comunique con la persona o lleguemos a un acuerdo, en pago, pero sí estoy de acuerdo.
Okay, he's asking, how would the payments be, Patrick? Because right now it might be a little bit difficult, but would I communicate them with the other party, or how do I make the payments happen? He's agreeing.
Yeah, the court would order it, and then he'd have to make payments, monthly payments. How much can he make a month?
El tribunal lo va a ordenar y usted luego tendría que hacer pagos mensuales. ¿Cuánto usted puede pagar al mes?
En ese caso, sí me podría dar tiempo de pensar, pues podría dar 100, porque ahorita puedo, por todo lo de la corte, no sé cuánto es my valle.
Sí. So
Pero
he's saying,
es más, le puedo dar más.
sí,
A mí sí
he's
tengo
saying, déjeme, por favor, un momento. He is saying, Patrick, he's saying 100. About 100 I can do right now because of, I don't know how many other payments I'm going to have right now with my sentencing and everything else. And then if I can pay more later, I can pay more later.
Yes, we can tell the court $100 a minimum a month.
Okay, le podemos decir a la jueza $100 mínimo al mes.
Sí, está bien.
That's fine.
Okay, and I'm going to ask the city attorney about the deductible because there's nothing on here about a deductible.
Le voy a decir a la fiscalía también acerca del deducible, porque nadie ha mencionado nada acerca de ese deducible.
Está bien.
That's fine.
Miss Massey, is it possible just to have Miss Gianoli back in so I can ask her some questions before we go on the record with the judge?
Absolutely. Letting her in now.
Thank you.
Un momento, señor, que vamos a traer a la abogada fiscal.
Está bien.
Miss Gianoli, can you hear me?
I can. Thank you, Patrick.
Thank you. I just have a couple questions on the bill. Typically, we see somebody paying it and then the insurance has the deductible. This one says that the insurance is paying almost $3,000 and then there's a balance of $37.87.29. I don't understand that because it says the deductible $1,000, insurance pays $27.87.29, but then they are requesting $37.87.29. So I don't understand if there's a deductible. Why is there still this much money? Do you understand this?
So what he told our advocate, and I have limited information given that I'm just saying.
Sorry to interrupt real quick, but just to let you guys know, I need to step away for a few minutes. I'm going to go ahead and leave you here in Reno. I'll be right back.
He was out that. The insurance, it looked like they paid the $2,700, but he was out the $1,000, according to what he told our advocate.
Okay, so the remaining balance of $37,829 is not what this individual owes. He owes the deductible of $1,000.
Yes, he's out the $1,000. That's what he's seeking that I ask for.
Okay, yeah, it was a little confusing because it looks like the insurance covered some of it, but didn't cover it. Okay, thank you. I appreciate that. Miss Interpreter, will you let him know that the deductible is $1,000 and that's what he's on the hook for?
Okay, entonces $1,000, señores, el deducible, y parece ser que lo único que le están pidiendo son los $1,000.
Okay.
Okay.
Bueno.
¿Está bien? ¿Eso es bueno?
Sí, es muy bueno para mí.
That's very good for me, he says. Okay.
All right, we're ready to go. Thank you, Miss Massey.
You're welcome.
All right, Mr. McGinnis, have you had ample time to speak with Mr. Reza about the restitution issue?
I have, Your Honor. Thank you.
Do you want to interpret that, Ms. Severio?
Yes. La pregunta fue, señor, a ver si el señor McGinnis tuvo suficiente tiempo para hablar con usted acerca del asunto de la compensación y el abogado dijo que sí.
Sí, está.
Yes, that's fine, Your Honor.
And Mr. Reza, do you believe you've had enough time to speak with Mr. McGinnis about this issue?
Señor Reza, ¿usted cree que ha tenido suficiente tiempo para hablar con el señor McGinnis acerca de ese asunto?
Sí, lo tuve.
Yes, I did.
All right, then we'll go ahead and allow Ms. Gianoli from the city to make her argument for sentencing.
Okay, ahora la señora Gianoli va a dar sus argumentos para la sentencia.
Thank you, Your Honor.
Gracias, su señoría.
As you can glean, Judge, this was an accident case.
Como usted puede entender, su señoría, este fue un caso en el que hubo un accidente.
It appears that the defendant rear-ended the victim vehicle.
Parece ser que el acusado chocó por detrás con el vehículo de la víctima.
When law enforcement made contact with him,
cuando los agentes del orden público tuvieron contacto con él,
he exhibited the standard observations indicative of alcohol consumption and was unsteady on his feet.
Él tuvo las observaciones típicas objetivas de consumo del alcohol. Él no podía estar estable o equilibrado en sus pies.
He claimed to have consumed 3 beers approximately 15 minutes prior to driving.
Había admitido tomar 3 cervezas aproximadamente 15 minutos antes de conducir.
Law enforcement conducted the horizontal gaze nystagmus,
Las agentes del orden público llevaron a cabo la prueba del nistagmo horizontal.
in which he exhibited 6 out of 6 clues.
Él exhibió 6 de las 6 pistas necesarias.
They attempted the walk and turn.
Intentaron hacer la prueba de caminar y girar.
The defendant was unsteady on his feet.
El acusado no podía mantener el equilibrio.
And given his age, they determined that it ultimately be unfair to have him continue that test.
Debido a la edad de él, últimamente al final determinaron que no era justo hacerle hacer esa prueba.
His BAC was quite high, judge, at a 288.
El contenido de alcohol en sangre, su señoría, fue bastante alto, 0,288.
His alcohol evaluation comes back for 8 months to 1 year.
La evaluación de alcohol nos ha dicho que necesita tratamiento 8 meses a 12 meses.
So essentially a 2X or akin to a 2X recommendation.
Básicamente una recomendación 2X o similar a 2X.
Judge, candidly, he doesn't have a whole lot of history.
Su señoría, francamente, él no tiene muchos antecedentes penales.
He has a 2006 suspended license and a failure to appear.
Tiene 2006 licencia suspendida, una falta de comparecencia en el tribunal.
A 2014 trespass with no disposition.
En el 2014, una entrada ilegal, no hubo resolución.
And some older history in the 90s.
Y también algún historial más antiguo en los años 90.
As provided in the court documents, the victim in this case is seeking $1,000 restitution.
Como se proporciona en los documentos del tribunal, la víctima en este caso está solicitando $1,000 en restitución.
Which is the deductible they had to pay to rectify or repair their vehicle.
Es el deducible que ellos tuvieron que pagar para rectificar o para reparar el vehículo.
Judge, what I'm seeking here is sentencing.
Señoría, lo que estoy solicitando para la sentencia,
Considering this is an accident case,
considerando que este fue un caso con accidente,
high BAC,
contenido de alcohol alto en sangre,
recommended treatment for more elevated counseling,
se recomienda tratamiento para una terapia más intensiva,
and the restitution.
y la restitución.
I'm seeking a 90-day suspended sentence
Estoy solicitando una sentencia suspendida de 90 días
for 2 years,
por 2 años,
48 hours of community service giving credit for time done in custody,
48 horas de servicios a la comunidad, dándole tiempo por el crédito ya cumplido en la cárcel,
$530 fine,
una multa de $530,
$60 chemical analysis fee,
una tasa del análisis químico de $60,
victim impact panel,
panel de impacto a las víctimas,
the level 2X program,
el programa del nivel 2X,
185 days of the breath interlock device,
185 días con el dispositivo de bloqueo del arranque,
the $1,000 deductible to
el,
Mr.
Walker, el deducible de $1,000 para el señor Walker.
I've provided his mailing information to your court staff too, Judge.
Le he dado información al tribunal acerca de la dirección del domicilio del señor también.
And finally, conditions that he obey all laws and consume no alcohol or drugs, please.
Finalmente, condiciones de que él tenga que obedecer todas las leyes, que no consuma ni drogas ni alcohol, por favor.
Thank you.
Gracias.
Mr. McGinnis, on behalf of Mr. Reza, what would you like to say?
Señor McGinnis,
Sí.
por parte del señor Reza, ¿qué quiere decir?
Thank you, Your Honor. Ms. Reza recognizes this could have been a lot worse.
Gracias, señoría. El señor Reza reconoce que esto hubiera podido ser mucho peor.
Elevated blood alcohol concentration with an accident, somebody could have really been injured.
Un contenido de alcohol en sangre alto con un accidente, alguien hubiera podido salir muy dañado de esto.
He's thankful nobody was injured.
Él está muy agradecido de que nadie se hizo daño.
He's been in the Reno Sparks area for approximately 12 years.
Lleva en el área de Reno Sparks aproximadamente 12 años.
He does have a stable job at Sage Electronica for the last 6 years.
Tiene un trabajo estable en Sage Electrónica por los últimos 6 años.
Plus, he does have a sober place to live with a roommate.
También tiene un sitio sobrio donde él puede vivir con un compañero o compañera.
He's been in custody approximately 8 days.
Lleva bajo custodia aproximadamente 8 días.
The city's recommendation is more than fair.
La recomendación de la ciudad es más que justa.
I would just ask that you consider giving credit time served towards his fines too. Thank you.
Le pido por favor que le dé crédito por el plazo cumplido en la cárcel también para que pueda pagar las multas. Gracias.
Thank you, Mr. McGinnis.
Gracias, señor McGuinness.
Mr. Reza, the law affords you the opportunity to speak to me, particularly any lessons that you may have learned from this experience. Could you share those with me, please?
Señores, a la ley de la oportunidad de decir algo a mí, particularmente cualquier lección que usted haya podido aprender de esta experiencia. ¿Qué es lo que me quiere decir?
Primeramente, lo siento mucho.
First of all, I am very sorry.
Esto no vuelve a pasar.
It will not happen again.
Mi experiencia de estar aquí encerrado no es buena para mí.
My experience of being here at the jail is not good for me.
Y quiero decir muchas disculpas para todos.
I want to apologize to everybody.
Y si es posible, irme hoy a la casa para pasar el día de Thanksgiving con parte de mi familia.
If it would be possible, Your Honor, to be released today to be able to spend Thanksgiving with part of my family.
Esto es lo que puedo decir.
That's all I can say.
All right. I'm very happy that you don't like your stay at the Washoe County Jail.
Muy bien, estoy muy contenta que no le esté gustando la experiencia en la cárcel del condado de Washoe.
I'm hopeful that that means that you don't want to go back.
Espero que esto signifique que usted no quiere volver a este sitio.
I'm also worried that you were more than 3 times the legal limit in blood alcohol when you were arrested and you continue to drink after you went to jail.
También me preocupa que tenía 3 veces por encima del límite legal en alcohol cuando le arrestaron y luego continuó tomando también después de que le dejaran salir.
You understand that that makes you a very dangerous person?
¿Entiende que esto le convierte a usted en una persona muy peligrosa?
Sí, lo entiendo.
I do understand.
All right. I will do some things, though, to acknowledge that you have spent some time in jail.
Voy a hacer unas cosas también que van a reconocer que usted ha pasado cierto tiempo en cárcel.
I'm going to convert the $530 fine requested by the city.
Voy a transformar la multa de $530 que la ciudad ha solicitado.
To time served.
Le voy a dar crédito por el plazo ya cumplido ahí en la cárcel para pagar esa multa.
I will also give you credit against the obligation of 48 hours of community service.
También le voy a dar crédito, utilizar el crédito por el plazo cumplido en la cárcel para pagar los 48 horas de servicios a la comunidad que usted debe.
So you will not owe either more jail time or community service.
No va a deber más tiempo en cárcel o no va a deber servicios a la comunidad.
However, I will sentence you to 90 days in the Washoe County Jail with no credit for time served.
Sin embargo, le doy 90 días en la cárcel del condado de Washoe sin ningún crédito por el plazo cumplido.
I will require that you pay the $60 chemical test fee.
Voy a solicitar que pague $60 del análisis químico.
That you participate in a level 2X alcohol counseling course.
Que participe en una terapia 2X de nivel de aconsejamiento, terapia sobre el alcohol.
I'm going to set a case status hearing for you in about 60 days so you can show me proof that you were enrolled in the level 2X counseling.
Voy a fijar una audiencia para ver el estado de su caso como en 60 días para que usted me pueda demostrar prueba de que usted se ha inscrito en esta clase de terapia el nivel 2X.
I'm going to order that you install a breath interlock device on any vehicle you own or operate for a period of 185 days.
Voy a ordenar que se instale un dispositivo de bloqueo del arranque en cualquier vehículo del cual usted sea dueño o que opere por 185 días.
I will order that you pay restitution in the amount of $1,000 to the victims in this matter.
Voy a ordenar que pague restitución en la cantidad de $1,000 a las víctimas en este caso.
You may set up a payment plan.
Puede usted hacer un plan de pagos para pagar esto.
With the court.
Con el tribunal.
But I want this $1,000 paid within 12 months.
Pero quiero que los $1,000 se paguen en 12 meses.
I will also order that you have no alcohol or drugs without a valid prescription, including marijuana.
También voy a ordenar que no tome ni drogas ni alcohol sin una receta válida, incluyendo la marihuana.
And that you obey all laws.
Y que usted tenga que obedecer todas las leyes.
Do you have any questions about my sentence?
¿Tiene alguna pregunta acerca de mi sentencia?
No.
No.
All right, I'm gonna ask my staff to give me a case status hearing date about 60 days out. That should be sometime in mid-January. Mr. Reza, I will order that you come to court on that date and provide proof that you have enrolled in the level 2X counseling and that you are regularly attending.
Señor, entonces le voy a pedir a mi asistente que me dé una fecha en 60 días, va a ser como a mediados de enero, y señor Reza, en ese día, en ese enero, me tiene que enseñar prueba de que se ha inscrito en la clase y de que usted está asistiendo regularmente a esa clase.
Do you understand?
¿Entendido?
Sí lo entiendo.
I do understand.
I may have that date, please.
Yes, Judge, I have February 4th at 8:45.
All right, Mr. Reza, I will see you back in my court on February the 4th, 2026 at 8:45 for you to show proof that you're enrolled in counseling.
Ok, señor Reza, le voy a ver en mi tribunal el 4 de febrero, 8:45 de la mañana del 2026, señor Reza, para que usted me pueda enseñar prueba de que usted se ha inscrito en esas clases.
Sí.
Yes.
All right, and Mr. Reza, I'm going to release you today for Thanksgiving with your family.
Señor Reza, le voy a dejar salir hoy para la acción de gracias con su familia.
Please keep in mind that you are under a no alcohol clause for 2 years.
Por favor, acuérdese de que tiene una cláusula de no tomar alcohol por 2 años.
If you violate that clause or that order one time, I will put you in jail for 90 days.
Si incumple esto, señor, incluso si sea solo una vez, yo le enviaré a la cárcel por 90 días.
Are we clear?
¿Está claro?
Está muy claro. Gracias.
Very clear. Thank you.
All right, I'm going to also order that you appear at the Reno Municipal Court on Monday to set up all the things that I have just ordered.
También le ordeno, señor, que el lunes tiene que ir al Tribunal Municipal de Reno para inscribirse para todas esas condiciones que yo le acabo de dar.
Está bien.
That's fine.
All right, and have a happy Thanksgiving.
Pues feliz día de acción de gracias, señor.
Happy Thanksgiving to you too.
Judge, what's the sentence on the contempt charge?
Time served.
Okay, thank you.
Your Honor, are you able to take Butler next?
Sure, yes, I can. Louis Butler, thank you. Deputy Arenas Nunez. Mr. Butler, good morning.
Good morning. How are you?
I'm good, thank you. Let me find your case in my files. Just give me a moment. Mr. Butler, I have a matter here. The case number is 25 CR 17393.
25 CR?
It's CR stands for criminal.
Oh, yes, definitely.
All right, sir. So you have from November 22nd, 2025, sir, a charge of obstructing and resisting a police officer by flight, which tells me that you tried to run away from police officers. Did you understand the charge?
No.
Well, I can, have you gone over the facts and circumstances of his case with him, Mr. McGinnis?
I had, Your Honor. I don't know why he wouldn't recognize it.
All right. So, Mr. McGinnis, your lawyer has indicated to me, Mr. Butler, that he's gone over the facts of the case with you already.
Oh, yeah. Sorry about that. I've been bit up by a dog, so I'm off hella like drugs. I can't comprehend what's going on right now.
Okay, well, I'm going to tell you something. I'm going to continue your matter to the next court hearing based on what you just said here today.
Yes, ma'am.
All right, may I have a new date in videos for Mr. Butler?
Yes, Your Honor, that would be Tuesday. I believe that's the 2nd.
Yes. All right, Mr. Butler, hopefully the drugs and your medication will have left your system. I want you to be totally competent and coherent when you appear in front of a judge so you know what's happening. So we'll hold you until Tuesday, okay?
Yes, ma'am.
Oh, Your Honor, I apologize. It looks like there is videos on Monday on the 1st.
Okay, we'll
And
hold
Department
Mr.
3.
Butler until Monday for videos on Monday. The next matter I have is Brandon Smith.
Your Honor, he went back to his housing unit. He wasn't feeling good.
Thank you, Deputy. Richard Irwin. Good morning, Mr. Irwin.
Morning, ma'am.
Mr. Irwin, your case number is 25 CR 17481. I'll open up that file now and tell you, it looks like your charge is trespassing from November 24th, 2025. Did you understand what that charge is?
Yeah.
All right. And how do you wish to plead to that charge, sir?
Can I pay the fine? Or isn't there a fine that goes along with that?
No, before we do any of that sort of thing, I have to take a plea from you. How do you wish to plead?
No contest.
Very good. Now I'm required by law to ask you a series of questions to make sure you understand what's happening here this morning. The first question is, do you understand that by entering a plea of no contest, the court, which is me, will find you guilty of trespass?
Yep.
Yes? Was that yes?
Yeah, that's what I just said.
All right. It's not clear unless you tell me yes or no, sir.
Yes or no? Yes or no? Be quiet.
So I'll ask you again, Mr. Irwin, shall we continue this matter until Monday so you understand what's happening? Mr. McNally, would you like to intervene?
Your Honor, Mr. Irwin understands what's happening today. This was a trespass for McDonald's. It's my understanding he wanted to enter a guilty plea in the hopes that he can go to Thanksgiving dinner with his with his father. And so, Mr. Irwin, is that correct? You still want to enter a guilty plea? Mr. Irwin, can you hear me? Are you not responding, Mr. Irwin?
We can hear you, Patrick.
Jill can hear me. Mr. Irwin, can you hear me?
He can hear you, Patrick. He's just not answering.
All right, let's continue his matter. It sounds like he needs time to think about it. We'll continue his matter till Monday morning.
Well, that's unfortunate. I'm back, by the way. Hi again. We'll keep an eye on that. Let's go back to Judge Middleton. He's got a new contestant. Oh, hold on. There we go.
Sure, why not?
Good afternoon, sir. Are you Caden Jesse Ghost?
Yes, sir.
Mr. Ghost, you're charged in this complaint with disturbing the peace. That's a certain kind of statute. They didn't charge it on a disorderly person. They charge it as 75170, which is disturbing the peace in a public place. I say this a lot. It doesn't matter who was right or wrong, who started it. Was there a disturbance in a public place? Your lawyer says that you were intoxicated, so you don't have a clear memory of the incident. I do have a bond report, which I can use for the facts. If you do plead no contest to this matter, you'll be giving up your right to have a trial. Do you understand? There won't be a trial. Do you understand?
No, sir, I don't.
Well, if you plead no contest, there won't be a need for a trial. By pleading no contest, you don't admit what happened, but you also don't deny what happened. And you would allow or accept that a conviction would enter. So are you willing to plead no contest to this charge?
Yeah.
All right, did anybody threaten you to get you to plead no contest? Did anybody threaten you to get you to plead to this? Or promise you anything? You have to speak your answer.
No one has told me, sir. No.
All right, excuse me. So let's talk about this. Do you understand that if you do plead to this charge, there won't be any trial? I'm going to give you a fine and complete the sentence. Do you understand?
Yes, sir.
All right. If you had a trial, you'd have the right to be represented by an attorney. Mr. Truckee is here to represent you. He is also been appointed. You could have also hired an attorney if you wanted. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court, so they could be questioned under oath. You would have the right to take the witness stand and testify on your own behalf, but you don't have to because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. Do you understand?
Yes, sir.
And you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. All right. Can I use the bond information report that was provided?
Yeah.
Some people would concur with that, Your Honor.
All right, thank you. On November 6th at about 9 o'clock at night, they were at Little Caesars in Sturgis. And a guy called, his wife apparently got into it with you over your driving. She said, "Stop driving like a jackass." And then somebody said, "Hey, bitch." And then you got out and had a black gun in your hand. And they provided a description of you and the car. And then they found you. And there was a little bit of a scuffle there. And they searched the vehicle and found a gun. It's one of this thing get charged with more than this. You did spend 4 days in jail. There's enough facts in there for disturbing the peace. Do you remember what you were drinking?
Fireball, sir.
That'll do it. All right. Normally in disturbing the peace is do a time served and a fine. I'm also going to forfeit this gun.
It was a airsoft or something. It had been dressed up, just so you're aware, Your Honor.
Don't bring an airsoft gun to a real gunfight. Police will shoot you.
Well, Your Honor, what was concerning here is that the handgun had been the airsoft gun was painted black to look like a real handgun, and it did have live ammunition in it.
Yes.
So this could have been a very bad situation that could have resulted in his being killed by the police in some type of a shootout if they really deemed him to be a threat to themselves or the public. He also was a .11 PBT and wouldn't comply with the officers. So,
but you didn't get charged with drunk driving. You didn't get charged with felonious assault. You didn't get charged with brandishing a firearm. You didn't get charged with any of the other stuff that could have accompanied this. So I see why Mr. Truckee wanted to get in and get this plea in the can. But,
Your Honor, can I say something?
Yes, sir.
So I'm going through a program too. I don't know if you know. I'm getting on a bus at was at 8:15 tonight to go to a program.
Good. Which one?
It helps the better. It's called Good Samaritan. I think it's in Texas. But yeah, I had a bus ready for me at 8:15. I was gonna head down there, and that was gonna help line my life up and fix me.
Well, is that still the plan?
Oh yeah.
All right, that's a good plan. All right, 4 days jail, credit 4 days. $75 crime victims' rights fee, $50 state minimum fee, $150 attorney fee, this $75 fine. That adds up to $350. You posted $100 of bond. I mean, $250. Probably warmer in Texas than it is here. They could do by next year, so that you get situated down there, March 30th of 2026. Mr. Ghost, this seems like a better plan than some I've heard. You can come get this. The bailiff left me when they took those guys into custody and went to lunch. I wish you good luck. How old are you?
I'm 20.
Well, this is a good time to address this stuff. You're gonna end up like the last two guys who are not doing well at all. All right, sir, you're good to go.
Thank you, Your Honor.
Thank you.
Thank you,
You can take care of yourself, young man. Get on that bus or
I
Texas.
appreciate you.
All right, hopefully he gets himself together. Before we move on to the next court, I do want to point out that the other sponsor for today's program is us, the Courtroom Files. If you go to courtroomfiles.com, you will find that we currently have our Black Friday sale going on all of our merch. Everybody gets 15% off when they use the code that's displayed at the top of the site. If you are a channel member, you get 25% off, and that code is available to you in the members-only posts and also over in the members-only Discord. Hi, Ellie. So be sure to check that out. We've got a lot of good stuff over there, several new items for Christmas. Plus, the thing I'm most proud of, you can see on the screen right now, is our 2026 wall calendar, the theme of which I call Street Justice Graffiti Art. It's very cool. Every month is themed to what the month represents. Be sure to check that out. It's priced very well, right in line with calendars that you would get at major retailers and everything. So give that a look. Help support the channel as well, and you get something cool. It's a win-win-win-win-win-win-win. That's probably enough wins. All right, let's go back to Judge Collada. He's been grumpy, and he's got another contestant. Let's see how this goes.
We're here in 25 CR 1390, State of Ohio versus Dantes Summers. You are Dantes Summers?
Yes.
You were scheduled for an arraignment this morning at 8 o'clock.
Yes.
It's now 11 o'clock.
Yeah, I ain't had no ride, and I
You had no ride. Well, you represented that when you were given a bond in municipal court that you'd be able to get to court on time. Now, if you can't, I can make sure you will be by putting you in the jail and bringing you over when you need to come over.
No, I can find a ride on time. Today was
You didn't.
Today it was different. I didn't.
No, why? How do I know other days aren't going to be different then? Yeah, there's a warrant being prepared for you right now. You were supposed to be here at 8 o'clock and you weren't. We issued a warrant. It hasn't been issued yet, but it's being prepared right now. Why shouldn't I do that?
I'm gonna make it on time next time. I'm gonna make sure.
This isn't like an open house that you come and go whenever you want when you have a summons or a court date.
Right.
Well, that's how you treated it. And I'm trying to figure out why I should just continue the bond here when you didn't show up when you were supposed to. That's what a bond is for. It assures your appearance at court dates and court hearings when you're supposed to be here. And you just don't get to come when you want to come.
Yeah, I wasn't purposely coming when I wanted to.
Well, but that apparently is going to be an issue. I mean, how can you assure me it's not going to be an issue in the future?
I'm gonna have. I got a car now, so I'm getting it fixed
today.
today.
You got a car now?
I have a vehicle. I just purchased a vehicle about 2 days ago, and I'm getting it fixed. It was broken down. I'm getting it fixed today. I was working on getting it fixed today.
So how'd you get here?
My sister.
Where's your sister now?
Outside.
Outside here or outside? Outside.
Outside in the parking lot.
So my bailiff walks out there with you to the car, so he's going to see your sister?
Yes.
Where are you living now?
18409 Hiller Avenue.
What's the address?
18409 Hiller. 18409 Hiller Avenue.
Paperwork says 1849.
1849.
1849 or 18409?
18409 Hiller
Yeah, see,
Avenue.
the paperwork from Willoughby just says 1849. There's no 0. I mean, you put the 0 in the paperwork. I'm not blaming you for this.
Okay.
When you filled out the paperwork, you put the 0 there.
Yeah.
Willoughby, did something wrong. I'm just saying that address we have is not the right address. At least that's what Willoughby provided. And the prosecutors actually did prepare the warrant. It's being recalled because you appeared here, unless I put a stop to it. How'd you know about today's hearing?
I had a paper. The paper said Monday. The paper they put on my door. Monday through was like a little red copy.
So you got something brought to your door?
Yeah, red
even
copy.
though they didn't have the right
But it didn't have a date on there. Like the date was blank on there. It just said.
That's not. I'm looking at the summons right here. It has the date on here.
Like the red paper. It said letters, and then it was the.
Yeah, I have a summons here that says. Then how'd you know to come today?
By the paper, it told me Monday through Friday, and Monday I came today because it was the closest day when they told me to come.
When did they tell you to come? This isn't making any sense.
I called the lady.
And how'd you know you were even late? What were you late for if you didn't have a date?
I didn't know about the date. That's the lady. When I called the lady, she said you're welcome to come anytime Monday through Friday. I didn't know about this day today.
You just showed up here at 10 o'clock today.
I came for when I seen the red paper. I came today for that, to pick up these papers. They just told me about these papers. I didn't get no date about today.
Your Honor, if I may, just to clarify, I do believe he's talking about the summons today because he was never served with the summons until today when he arrived at the jail.
Why did he arrive at the jail today?
Your Honor, I don't know because I don't know necessarily what paper they leave at doors. I tried grabbing the file, Your Honor. I was not able to obtain the file from the assigned attorney on this case to see about the contact with Mr. Summers or not. So unfortunately, I had very little information, but just to clarify, I believe it is the summons he is talking about. He was just served with it at the jail today. So I don't know if they leave a card that says appear, one of these days to be served. I'm not too sure of the ins and outs, Your Honor. I apologize.
All right, I will allow Caban to be continued. So you need to fill out this paperwork, Mr. Tomasic and Mr. Summers, about that.
Okay.
And then, hang on. And then here's your scan. Conditions of bond form. Make sure you put the correct address on there. You did it the last time, but make sure it's the right address there. And then once this gets filed, your case will be assigned to one of the 4 judges. Could be me, could be one of 3 other judges. And then your lawyer will let you know when the next hearing date is.
Okay. And they will call me, correct?
Sorry?
They'll call me for the hearing, right?
Who's they?
My attorney.
I don't know, ask her. I have no idea. I don't know how they do it, but
Yeah, we usually send out notices, then Chad will give you a call.
Yeah, I was scared because I didn't get
you need to make sure you get all your court dates on time.
Okay, I'm going to make sure I'm there on time for sure.
All right.
All rise.
Thank you, Judge.
I'll say this for Judge Collada today. He's consistently cranky. Let's, hi, Ellie. Let's go back to Michigan, Judge Wiggins. See what's going on there.
Appearances, counsel.
Joanna Carey, for the people.
Robert Hartel from Ms. Shattuck, who joins me at the table.
We are here for looks like a pretrial. Is there any resolution in this case?
Yes, Your Honor, it's my understanding the defendant plead guilty to count 1, operating with a high BAC, and the people will dismiss count 2, operating while intoxicated.
Mr. Hartel?
Yes, Your Honor, and I've explained to her that's essentially the equivalent of pleading as charged. She understands.
And I don't see a substance use assessment, so I assume we'll have to set this for sentencing.
Yes, she has advised me, she has reached out to Catholic Human Services, so it might be sooner than usual, but yes, Your Honor.
All right. Ms. Shattuck, have you heard what the attorney just said the resolution in this case is?
Guilty.
Guilty, you would plead guilty to operating with a high BAC, and the people would dismiss the operating while intoxicated. Yes?
Yes, sir.
Is that your understanding of the plea agreement?
Yes, sir.
Will you please raise your right hand? Do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
All right. So it's my understanding that you'll be pleading guilty to count number 1 of operating with a high bodily alcohol content. That is a misdemeanor punishable by up to 180 days in jail and or a fine of $200 to $700 and or 360 hours of community service rehabilitative programs, possible vehicle immobilization, and reimbursement for governmental expense and prosecution fees. In exchange for that, the people will be dismissing count number 2 of operating while intoxicated. That is a 93-day misdemeanor and fines, costs, and the same penalties as the other charge. Now, do you understand that the prosecution could not try you on both? They would have to try you on one or the other. Do you understand that?
Yes, sir.
Does that have any impact on your decision to plead today?
No.
Back on November 7th of this year, were you on probation or parole?
Oh, yes, sir.
Has there been a violation in this case?
Sorry, please.
Other than this case.
Oh, no.
Oh, okay. All right. Were you on bond at the time on any other file?
No, sir.
Do you remember reading and signing the advice of rights form, talk about your rights to an attorney and your rights to a trial?
Yes, sir.
Did you understand those rights?
Yes.
Most importantly, do you understand that you have a right to a jury trial and that by entering a guilty plea today, you'll be giving up that right and you won't have a trial of any kind?
Yes, sir.
Knowing that, then, has anybody promised you anything in order to get you to plead other than the agreement?
No.
Has anybody threatened you in any way?
No.
And is it your own free choice to plead today?
Yes, sir.
Are counsel aware of any other promises, threats, or inducements not made part of the public record? I'm sorry, not made part of the record.
I'm not.
Nor am I, Your Honor.
Then, Ms. Shattuck, to the allegation that on or about November 7th, 2025 in Herring Township of Wexford County, how do you plead to count number 1 of operating with a high bodily alcohol content?
Guilty.
In order to accept that plea, I must have you tell me what it is that makes you guilty. So back on November 7th, were you operating a motor vehicle in Herring Township?
Yes, sir.
And prior to operating that vehicle, had you consumed alcohol?
Yes, sir.
What did you have to drink?
Vodka.
How much?
Quarter.
I'm sorry?
Quarter of the fifth.
A quarter of the fifth. Ms. Carey, are there chemical tests to support the plea?
There are not. There was a blood draw. However, there was a PBT with a 0.223.
We would stipulate to that, Your Honor.
All right. So Ms. Shattuck, I want to cover that with you. So a PBT is not admissible at trial to establish as one bodily alcohol content. It would have to be what we refer to as a chemical test. So either the blood draw or the used to be Datamaster, now it's the Intoxilizer 9000. Sounds something right out of a scientific movie. But what is happening is that your attorney and Ms. Carey are agreeing to use the PBT. They're stipulating to use the PBT for purposes of the plea. Do you understand that?
Yes, sir.
All right. And are you okay with that stipulation?
Yes.
Do counsel believe the defendant has provided a factual basis in which to accept the plea and the court rules have been complied with?
Yeah.
I do too, Your Honor.
As does the court. I find the plea is knowing, voluntary, and accurate. Ms. Shattuck, pursuant to the agreement, I do find you guilty of operating with a high BAC, and the operating while intoxicated will be dismissed at the time of sentencing. We will set this for a plea and, or I'm sorry, for a substance use assessment and a sentence. Is there anything else for the record, counsel?
What was it?
Oh, I'm sorry.
Bond violation.
Oh, wait.
Oh, that's-
She pled to that.
But to that.
Yeah.
And then you forfeit.
And that's why she's in there. I remanded her and forfeited the bond.
Okay.
Anything else?
Your Honor, I believe I would have an ethical obligation to at least see if we could address bond. I realize the court or the prosecutor might have a position on that, but still, thank you.
I will leave it up to Ms. Carey whether she'll waive time
I
requirements.
will waive the time limits, but I do oppose any.
Sure. Mr. Hartel?
Thank you, Your Honor. My client obviously has pled guilty. She has every desire to resolve this situation. I have talked to her about how my office social worker, Mr. Henderson, is going to reach out to her and see what resources we can provide to help her. Obviously, when someone has high blood alcohol content, is a bit alarming, especially when it's hard alcohol, and we do want to make sure that she's not back in the system in the future. I don't want this to sound too much like a sentencing argument. But what I will say is she is motivated. If she needed to use the daily testing device, she'd obviously be willing to comply with that. We realized there was issues in the past, but she has every desire to do well on bond. If the court was hesitant about that and willing to consider immediate release to treatment, she doesn't have anything lined up. But I was getting at our office social worker, Mr. Henniger. He's very good about helping with that. I just would prefer not to see my client lodge pending sentencing.
Ms. Carey, I know you said you oppose it. Do you want to make an argument at all?
I would like to, Your Honor, thank you. Number one, the PBT is quite high. It's well over 0.17 high back limit. She did have a prior drunk driving conviction in 2017. And frankly, Your Honor, in this case, her husband is the one that called the police because she left the house to drive to Culver's to pick up their daughter, and he did not want their daughter to get in the vehicle. That's where she was found, is at Culver's. I believe they saw her driving in the Culver's parking lot eventually. I think, and then we had the bond violation for a positive alcohol test. This is very concerning. I would be more amenable to a release to treatment if we had that, which is not what's being requested here. And I think, frankly, for public safety right now, I would ask the court to continue the current situation. Thank you.
Thank you. Any rebuttal, Mr. Hartel?
Nothing wrong.
All right. Well, the defendant has in her prior history from 22, a disorderly drunk, and 21, a domestic under 4A, and then the operating while impaired or intoxicated that Ms. Carey referenced back in 17. The high BAC in this case is a 0.223. And then as Ms. Carey said, we already had the violation for positive blow back on, or at least a positive test back on November 16th. The defendant previously was placed on daily alcohol testing. The court is going to deny the request for bond modification. However, Mr. Hartel, if you are able to get treatment lined up, you are always more than welcome to rebring a motion.
Oh, thank you.
All right, thank you. Ms. Carey, are you ready for Mr. Wood yet? No?
Yeah, I am.
You are? Okay.
That makes sense to you.
Court calls the people of the state of Michigan versus Brian Jerome Wood.
Sheets, I don't know.
This is case number 254739FD. Appearances, counsel.
Joanna Carey for the people.
I'm Jeff Harrison. I'm here on behalf of Brian Jerome Wood. He's next to me. We do have some paperwork we need to discuss between the two of us, Your Honor.
All right, I'll give you a moment to do that.
Thank you. Sorry, the perfect storm.
You're fine. I understand there's a lot going on.
All right, well, he's muted. Let's go back to Reno and continue there.
Required. You were given a citation for those 3 traffic offenses in order to come to court on October the 14th, 2025. It's alleged that you failed to appear on that court date. Did you appear for court on October the 14th?
No, I did not.
So are you admitting that you failed to appear?
Yes.
And do you understand that failing to appear is contempt of court, for which I could sentence you to up to 25 days in jail and fine you up to $500?
Yes.
And did you understand your constitutional rights?
Yes.
You have any question about those rights?
No, I don't have any questions.
And have you served in the United States military, Ms. Montgomery?
No, I was supposed to have my driver appointment yesterday with the DMV, and I don't have the car anymore. My boyfriend took it back from me, so that's where I'm at now.
All right, well, I'm going to work with you as to those traffic offenses, okay?
Yes, ma'am.
All right, the first thing, though, is I will accept your admission to the failure to appear as freely, voluntarily, and knowingly entered. So is the city prepared to tender Ms. Montgomery an offer relative to her traffic offenses?
I am, Judge. If she wants to enter a plea to the no insurance, I'll make a motion to dismiss the no license and the no registration.
So do you want to accept that offer, Ms. Montgomery?
Yes.
All right, and what is your plea to not having insurance on 9/11/2025?
Guilty.
Okay, and you understand by entering a plea of guilty, you're giving up your right to have a trial in this matter?
Yes.
Did you understand the constitutional rights that have previously been described?
Yes.
And you understand that this is a misdemeanor offense for which you could be sentenced up to 6 months in jail and fined up to $1,000?
Yes, ma'am.
All right, and we've already established that you're not a veteran, so I will accept your plea as freely, voluntarily, and knowingly entered. The good news for you, Ms. Montgomery, is this. State law requires that I fine you $748. I'm going to do that today. However, I'm going to give you an ample amount of time to go out and get a policy of insurance that covers you, either getting on a family member's policy or getting online and getting an operator's policy of insurance, which is available for people who don't have a car.
Yes,
And
ma'am.
the reason I'm making that offer to you is that if you get insurance within the time period you and I agree upon, I'm allowed to reduce your fine down from $748 to $200. That's a $548 savings. Are you willing to do that?
Yes, ma'am.
All right, so I will go ahead and give you how much time? I usually give people 60 days, and 60 days is by the middle of January. Can you get insurance by January the 26th?
I have to get another appointment with the DMV, and the DMV appointments are so iffy right now. If I could get a little bit longer, I'd appreciate it, but.
All right, I'll give you 90 days.
Thank
And
you.
that's February 24th, 2026.
Yes, ma'am.
All right, so, and that will be, now you're going to need to, when I release you from jail today, I'm dismissing the driver's license charge and the registration charge, but in order to get insurance, you're going to have a driver's license. So you're going to need to get those things taken care of, even though I'm dismissing the criminal charges. Do you understand?
Yes, ma'am. I'll make an appointment.
I will dismiss those. When were you arrested on this outstanding warrant?
Friday.
All right, and is that enough time for you to remember that you need to make all your court appearances?
Absolutely.
All right, then as to the failure to appear, I will sentence you to time served. As to the insurance charge, you're sentenced to $748 today. You're going to be given until February 24th, 2026 to provide after the fact or subsequent insurance, which will then reduce your fine down to $200. And then we can set up a payment plan for the $200. Do you want to go ahead and do that?
Yes, please.
All right, you're sentenced to time served on the failure to appear. You should be released today. I am ordering though, Ms. Montgomery, that you appear no later than close of business Tuesday afternoon to the Reno Municipal Court to set up this agreement, okay?
Yes, ma'am. Thank you.
That'll be my order. You're welcome. Happy Thanksgiving.
Happy Thanksgiving.
Michael Slabicki.
Morning, Your Honor.
Good morning, Mr. Slabicki. Just give me a moment to open your file.
Yes, ma'am.
All All right, sir, your case number is 25 CR 17513. I'm opening up your file now. And it looks like you had from November 24th, a series of misdemeanor offenses, and they are as follows: drinking or possessing an open container of alcohol in public, urinating or defecating in public, and trespassing. Did you understand those charges?
Yes, Your Honor.
And Ms. Giannoli, are you prepared to tender an offer to Mr. Slabicki?
I am, Judge. If he wishes to enter a plea to the open container and the trespassing, I'll make a motion to dismiss count 2, the urinating offense.
You want to accept that offer, Mr. Slabicki?
Yes, Your Honor.
And what is your plea to the open container of alcohol
No
charge?
contest, Your Honor.
And how about the trespassing?
No contest as well. I was unaware. It's been a while since I was over there. I'm sorry.
Well, and I want to tell you, Mr. Slabicki, a lot of casinos and private businesses now employ the 3-year rule, which means if you've been trespassed, you'll have to stay away from those establishments for a period of about 3 years. So please be warned.
Yes.
That any place you've been trespassed previously doesn't want you around for that protracted period of time. I'm going to ask you, sir, if you understand by entering pleas of no contest that the court will find you guilty of the trespass and the open container charges?
Yes, Your Honor.
Did you understand by entering a plea of guilty or no contest, you're giving up your trial rights?
Yes, Your Honor.
Any question about those rights, sir?
No, ma'am.
You understand the maximum penalty for each of those offenses could be up to 6 months in jail and or a $1,000 fine?
Yes, Your Honor.
And have you served in the military, sir?
No, ma'am.
The court will accept your plea as freely, voluntarily, and knowingly entered. City's recommendation is to sentence, and I will dismiss the urinating in public charge pursuant to negotiations.
Thank you, Judge. Here it appears the defendant was outside the vitamin shop when law enforcement made contact with him. He had an open container of natural ice in his hands. The vitamin shop indicated that he had been trespassed from the property 2 months prior and that he had urinated on the side of the building. Judge, his court services information is concerning to the city. He has a history of nuisance offenses. He was most recently released from jail just several days ago, on November 22nd. In looking at RMC, he's had 9 cases in 2025. The most recent was another trespassing, although that was at Atlantis Casino, not the same place. But frankly, it doesn't look like Mr. Slabicki is getting the message. He continues to come in and out of custody. We saw him just a handful of days. What I'm going to ask, Judge, on the trespassing is that we do a 30-day suspended sentence for 1 year, conditions that he obey all laws, consume no alcohol or drugs, and that he stay away from the vitamin shop. And I'll ask for time served on the open container, Judge.
Thank you. Mr. McGinnis, on behalf of Mr. Slabicki, what would you like to argue? You're muted. Mr. McGinnis, you're muted. Sorry.
Thank you, Judge. So my understanding is my client's been in custody approximately 2 days. It's unfortunate that he chose to urinate on a building. I recognize there's not a lot of places to go to the restroom around that area. Regardless, the property owner was very disappointed and upset. He informs me that if he's released from custody, he's going to go down to the CARES campus. He's going to start working with the case manager, hopefully. He recognizes that the temperatures have dropped significantly and that he's going to need some housing. So hopefully he takes care of business down there and gets some resources.
Right, thank you, Mr. McGinnis. Mr. Slabicki, you want to add anything? I invite you to make a comment, sir.
Yes, Your Honor. I usually used to use the restroom inside the Qdoba Mexican Eats, but then they don't stop letting me go in there. So that's kind of the excuse for the building. If I recall the day that it happened, but I think it was 2 months ago, ma'am.
All right. And you understand that you're required to stay away from there?
Oh, yes, the whole complex, I believe.
All right. And your plans for how to handle your housing situation as the weather turns colder and colder?
I'm still working with my family that lives back east. We're in litigation. I have a lot of family problems right now, ma'am. But I'd like to get out of here.
All
so
right.
maybe go home.
Where will you go?
I am originally from Pennsylvania, where my family lives, Your Honor.
And do you have the ability to go back to Pennsylvania?
I'm talking to them. Hopefully they see what's going on with me and they'll forgive me for some prior familial problems.
All right. And you may want to talk to inmate assistants there at the jail to see if there is in fact somebody who can help you as well. I'm going to go ahead and give you a little bit of a break with the hopes that you do return to Pennsylvania. I'm going to send you to 20 days in the Washoe County Jail. That sentence will be suspended for a period of 1 year on the following conditions: that you obey all laws, that you have no alcohol or drugs without a valid prescription, including marijuana, and that you stay away from this vitamin shop in the complex from which you have been trespassed. Do you understand those charges?
Yes, Your Honor.
And of course, obey all laws if I didn't say that.
Yes.
I'm going to wish you good luck, Mr. Slabicki. Hopefully your family and you can reunite and you can take care of the problems that you're facing right now. So good luck.
Thank you, ma'am.
Sorry, sir. Your Honor, I have one more for the Reds list.
Yes.
Mr. Blackman.
All right, I'll go ahead and take him now.
Thank you.
Of course, Deputy Linus. Good morning, sir. Just give me a moment for my computer to continue updating. And may I have your last name again, sir? I don't seem to pick it up.
Last name Blackman.
There I have it. Thank you very much. I appreciate that, Mr. Blackman. Your case number is 25 CR 14511. I'm opening up your file now. And it looks like, sir, you were charged on September the 25th, 2025 with the crime of driver disobeying a police officer. You entered a plea of not guilty to that charge. And I don't see that the matter was set for trial. Let's see, it looks like an amended complaint was filed on November the 12th. I'll look at that and see what that is. Yes, so on November the 12th, 2025, one of the deputy city attorneys amended your criminal complaint to read as follows: a driver disobeying a police officer, to wit, that you on or about September 25th in the city of Reno, state of Nevada, in the vicinity of Galletti Way and Battleborn Drive, drove a motor vehicle on a highway or premises to which the public had access, willfully failed or refused to bring your vehicle to a stop when given a signal to bring that vehicle to a stop by a peace officer in a readily available vehicle. Do you understand the charge, sir?
Yes, Your Honor.
All right, and how do you wish to plead, sir?
I already had pled not guilty. I thought it was supposed to be set. I thought I had 60 days to do the trial on it, and I've been in custody over 60 days. And I already pled not guilty on September 30th.
So let's confirm that, Mr. Blackman. I'm concerned about that. That's a pretty significant amount of time to be waiting in custody for a trial.
If I may, Your Honor, I know that Department 4 issued an order to produce the prisoner, so there may be some issue with him refusing to come to court.
Okay. Did you ever refuse to come to court, Mr. Blackman?
Today, but then they came and said that I had to come to court.
Okay. Oh, that's because we don't want to violate your speedy trial rights by you sitting in jail, basically being unattended when we can process your case. I either set the matter for trial or take a plea, so you're not just wasting away in jail. How do you want to proceed?
Well, I mean, I don't know. It's past the 60 days, but I mean, I just want to say that, I mean, if it could be dismissed because of some of the fact that, I mean, I have other charges out of district court anyways. I mean, I'm facing a life sentence in district court. So, I mean, it's like, this is a minor misdemeanor case that also, too, I don't want anything to happen in this case because I have a 2-year suspended sentence. And basically, if anything happens in this case, then I'll probably get sent to prison, which will mess up my other case that I'm still fighting. So,
all right. Well, let me hear from your lawyer then.
Your Honor, I'm unaware whether or not he failed to be transported to court as a result of having a trial date. I read the order last night. There was an order to produce him. I'm not sure if that was as a result of him not showing up for his trial date. I don't have that information. He does have probably 6 or 7 pending felonies, and he is looking at a life sentence. Bail had already been set on this case for $1,000.
All right, and do you believe that his speedy trial rights were violated in such a way that you're making a motion to dismiss those charges here today, sir?
Your Honor, I don't have enough information for that. I know that there was an order to produce the prisoner, which tells me that he failed to come to court as a result of having a trial date, because he would not have been in videos for a entry of plea where he already entered his plea. So I don't have enough information as the Department of 4 issued the order.
All right, and your position, Ms. Gianoli?
Your Honor, I don't see, similar to Mr. McGinnis, I don't have a lot of information. I'm looking in Odyssey quickly. I don't see that there's been a violation of his rights. I also note that he has some very serious holds. This would likely be a time served thing if he wants to resolve it that way today, but aside from that, no further information.
So you heard Mr. Blackman, the city attorney has indicated a plea negotiation that if you want to enter a guilty or no contest plea to the charge of failure to obey a police officer, she would be recommending the time you've already served in custody and close this matter out. Is that something you may be interested in?
Well, I would like to resolve it. I just don't want that like on my driving record. So like I said, I mean, I'm facing a life sentence. I mean, it's a misdemeanor charge, time served. So that's why I would ask respectfully if it could just be dismissed so I could just handle all the rest of my stuff.
Well, I don't have the power to dismiss it based upon, I don't see any legal basis to dismiss the charge. However, the city attorney has already indicated to you by way of negotiations that she would be recommending time served to close this matter out. And I believe that it would not have, I can't say anything about your parole. I don't know anything about your parole conditions, but I can tell you that this duty to stop for a police officer is not a 12-point violation, which would cause the revocation of your driving privileges.
I'm just worried about it for my probation violation. So if you could just, if you can't dismiss it, could you set it out till after January 14th? Because that's when I go for my revocation hearing.
Yes, we can do that. So I will go ahead and continue your matter pursuant to your request. Continue this matter out till after January the 14th. We will maintain your not guilty plea. Okay?
Okay, thank you.
All right, let's give you a trial date. Hold on.
Because I'm getting one for you.
It's taking a moment, Mr. Blackman, because it's a whole new calendar year and a lot of our dates have not been set yet till after the
We have
first.
January 21st at 8 a.m.
All right, does that work for you, Mr. Blackman?
Yes, ma'am.
All right, we'll go ahead and set that trial date for January 21st at 8 a.m. And we will see you on that date.
Thank you, Your Honor.
And just for the record, the bail is set currently at $2,000.
All right, that bill will remain in effect unless anyone has any objection.
No objection.
Okay.
Thank you.
All right, you're excused, Mr. Blackman.
Okay, friends, a couple of minutes early, but this is the logical place to call it a day. I hope you all have a good Thanksgiving tomorrow. Enjoy your time with friends and family and whatever it is you do for Thanksgiving. We're going to do something real different here. We're going to do chicken and waffles. We like to change things up a little bit, so we're going to do some homemade chicken and waffles, and that'll be fun. I had fun with you guys today. I hope you did too. Interesting courts, a lot of grumpy judges, except for Judge O'Neill. She is never grumpy, which is kind of nice. She's a place to go. It's just kind of mellow. But it's interesting because the cast of characters there is totally unique and odd, so it's kind of a duality kind of thing. But we have every intention to be back on Friday. There should be some courts running, first appearance, bond, something like that. So we're going to attempt to do a Black Friday TCF live, and we'll see how that goes. And we'll be posting videos throughout the day today and tomorrow as well, so be sure to check those out. If you're traveling, safe travels. But again, enjoy your time with friends and family. Look forward to seeing you all again real soon. In the meantime, take care. God bless.